Ultimately, the matter pertaining to the construction of the road by virtue of the
Pass on the memo, sir. We'll take up.
extension of interim.
Yes, yes, please give.
It is final to make a mention. On the list, in the item number 47, this matter was taken up on 9th of this month by adjourning the matter to today and directing the state council, because my allegation is
So let it be called.
it may not be, so that I have paid.
Why you underestimate the pace of the court? Just wait.
So now they have.
Yes,
Let us see if we can.
item number 1.
Number one, madams. As for the instruction, madams, the communication has been received that 3 weeks time may be granted for giving the instructions, madam, as the file is very voluminous.
What a voluminous, sir. He has executed a work. Will you not pay the amount?
Madams, the part of the work was completed and part is not completed.
So whatever is completed, you are supposed to pay unless there is something. If you have raised any dispute, then you'll have to say that what dispute has been raised.
Weeks, madams, asking. madams.
What is this? The payment is pending for a long time.
Because I have already received the communication, they are already looking into the matter, madams. 2 weeks, they will be able to give proper instructions, madam. Because it involves calculation also.
What calculation, madam?
Whether this amount is disputed or not disputed, what is the.
So
their
what you were doing for a
corresponding-
long time, when they submitted the invoice, you could have immediately raised the issue, whether it is disputed or not disputed. But you can't sit tight over the matter for all time to come. Either convey your message.
Yes, madam.
Your decision has to be communicated so that they will take whether it is justified or not justified. When the council record her name and praise for an accommodation.
May it please your lordship. Petition of the inhabitants of the locality and public spirited person filed this application.
Oh,
Your lordship, kindly see page 13,
you are a public interested person,
public spirited person.
spirited person. Yes, what is this?
But
You have prayed for quashing the public notice.
my lord, I have also submitted objection.
Do you have any license, online or offline? Sorry, off or on shop or off shop? You don't have. So for whom you are espousing the cause? Marginalized section, economically weaker section,
No, this
for whom you have come with the PIL?
land is situated where authority concerned are going to open the IMFL on shop. That land is situated in a prohibitory place nearby,
Prohibitory place or a restricted place?
restricted place also, my lord, sorry.
Oh,
That is in nearby pond, nearby Dalit slum. And also
what is the law?
law, my lord, rule says, even if my lord,
Yes.
may I forget to place online if you have to notice.
Please show us the rule.
My lord,
Show us
notice,
the rule that
my lord,
oh, it's for the other side. Yes, give that exercise manual. Show us the act or a manual, what you want to. Huh?
2000 Odisha Excise Rules 2017.
17, yes. Which
Rule
rule?
31, my lord.
31.
Very limited for here.
No, let us see, sir. Let me understand, sir. You have read the brief, prepared the brief. Rule 31. Yes. Which portion of the rule you want.
Let's. My petition, my lord. I have.
No, rule,
My lord.
which according to you is offended by the
Rule 31, my lord.
31 what? Full.
Notice of the proposals for grant of license or exclusive privileges to be given to certain authorities before the 1st November or such.
Sir, that is a Martania, that's a head note. Give me from the text of the order,
Right.
the text of the provision. Sure.
Well, affix the public notice both in Odia and English in form number 8 as required under subsection 1 of section 20 and clause A of section 38 giving 15 days time therein for receiving objections. It is the very important, my lord, 15 days time. But authority concerned issued notice. Your lordship kindly see page 30 on
1-3. 1-3.
My lord, 1P.
Yes.
1P of the.
Yes. They issued on 10th of January.
10th on inviting objections by 25th January 2025. And also they have written that.
So 15 days notice is given.
15, but nowhere notice was published nowhere, neither in public place nor any authority.
What are you talking about?
Completely point to point 15 days, my lord.
No. Now, is there any provision which says that how publication has to be made to 32?
My lord. The head of the concerned local body shall cause a.
It is only in the official notice board of the local body.
My lord, nowhere. Petitioner came to know that latter, even if this.
If there is a statutory rule which provides the mode of the publication of the notice, then in that event, if they have exhausted that particular mode or complied the mode, can you say that it is not published in a newspaper, it is not published in the... can you? Because they are the creature of the statute. They cannot go beyond the statute. You come to Rule 32.
Well, publication of the notice in a local body, the head of the concerned local body shall cause a copy of the extract sent to it under clause A.
You are talking about A. You are talking about A, affixation.
My lord, affixation.
Correct. It is to be done where conspicuously affixed at the office notice board. So they have to show if they have affixed.
My lord.
That's all.
If this place is also restricted place, my lord, nearby slum.
Sir, if the objection does not come, then what? How can you hold them liable for offense or any departure from the?
Then, my lord, then.
Have you affixed in the notice board?
Instructions.
Objections has not been considered. No one has invited the petitioner, my lord.
To file objections.
Objection file.
They have done this. They have, I don't know about official records, but this has not, it has to be fixed.
It should after 25th or before 25th. Objection, what is the date of the objection filed by?
Objection, my lord, 22nd January 2025.
15 days.
Within 15 days.
Say that, yes, no difficulty then.
Whether we have received it or not, your lordship has been instructed.
Where is that objection? We can't read.
Page 14, your lordship.
Sir, we can't read, both of us.
I will seek instructions that it come next week, your lordship, I'll seek instructions.
I think you will be able to read that, but we can't read. So give me some time, I will be able to read. Definitely. I think the first word is a srijukto, or what is?
শ্রীযুক্ত
Huh?
জেলা পড়ক
Jila Pawan.
শ্রীযুক্ত কালেক্টর
I understand. So one word I can read.
I will seek instructions, Your Lordship, as to whether the notice, what the objection that we receive were considered and whether the notice would differ sufficiently.
Let them take instructions, listen. I don't know.
Copy of this,
In the meantime, we'll file translated copy my shop.
That's a rule also, Your Lordship. That is
that's a rule, I know, everywhere, it has to be. But normally the bench does not insist because they know this script, so they do not have any problem. My brother was asking that, see, that's correct. Yes,
I'll come within a week, Your Lordship, next
The-
Wednesday.
the application, the powers.
Item number 3.
Your Lordship, file a counter. Already filed counter activity, Lordship, and service reporting.
You have filed a counter,
Yes, Your Lordship.
copy, sir.
No, I haven't.
This is a public interest or?
Public interest litigation. In public interest litigation, unauthorized
Why the word counter is used in a public interest?
An
Say
affidavit.
affidavit,
An affidavit.
but why counter? Because it is not an adversarial litigation actually. PIL is never an adversarial
Yes, Your
litigation.
Lordship. I'm sorry, Your Lordship.
Is the state filed the affidavit dealing with the amendments made in the instant.
undertakers.
The Rome was not built in a day, can't be done.
Understand.
If it is all musical, it will come down both ways. Let us see first.
Item 4.
Which is Your Lordship?
Lordship, the petitioner had challenged the construction of a public health center at another place, though it was sanctioned by the government to construct it at the village of the petitioner. And on the last occasion, the Lordship had directed the government council to take instruction. The Lordship-
Change of a site. Wow, suddenly if you have issued a tender for construction at a particular designated place, can you unilaterally shift it to say another?
We had intimated the city, Your Lordship. We can't leave the station, Your Lordship, with all the health.
As a larger public interest, we understand.
Obliged to.
And that is the one that please for. And that's it.
Item 5.
Yes, sir.
Yes, Lord, I came back with the aspirant which I had given to your lordship. We cancelled that. Law is to be.
So when,
But actually, there is a difficulty. Your lordship to appreciate. Let me just explain. Actually,
just
there are.
1 minute, so that I will apprise my brother,
That's the.
he was not there.
Yes, my lord, I have provided. 10(6) provision. Section 6 of section 10.
For my brothers.
Yes. But your lordship would get it from the brief itself. It is there at page. Yeah,
Just, I understand. My brother was not there.
right,
You showed that amendment has come.
right.
Okay.
610.
Subsection 6 of section 10
Section 6
provides.
of section 10. Proviso, yes.
So, you-
we have taken care of the law has to prevail, your lordship said, we have respected it. Now, what is the difficulty, your lordship? Actually, prior to 2020 amendment, the proviso to clause Roman 2 of subsection 10 was any person, vice chancellor or any branch, the vice chancellor cannot manage two universities at a time. In 2020, they amended this. Milord, in 2024, there was an, Milord, your lordship may kindly appreciate. Earlier, this provision was, your lordship may kindly. Prior to 2020 amendment, the language was any person. Any person means normally we take the senior post professor of the university because it is for the interregnum. Somebody is kept in charge of the vice chancellor. It's not a full-fledged appointment. There is a mechanism. That's the principal statute. So, Lord, we are bringing an ordinance today to amend that and insert the old provision. We have to because we are not getting two vice chancellors cannot, and the ongoing situation in Lordship project is very difficult. But we have cancelled this. Since on the date of passing of this order,
Because that the amended provision was prevalent.
no, we are not going to validate. I advise them that we can override the pending judicial proceeding. We have to cancel it. So we are going for an amendment because experts are not available. There was no recruitment since 2020 because of the pendency of a case in Supreme Court. Just a minute.
There is
Finish.
Yes, ma'am.
He's answering. You have flagged an issue.
Yes, ma'am.
Now he's
No,
answering.
no, I have already answered. We have already cancelled. That's
So
So therefore
you have
we-
said that so far as this appointment is concerned.
we have cancelled.
You have
Can I pass on the order?
You have cancelled it.
Approved it. It is with the governor today. We are
Your
promulgating them.
grievance is better. Your grievance was that how can a head of the particular department can act as a vice chancellor, he holds this particular statutory provision.
Yes, ma'am.
Well, we seen, you cited us the provision where the neighboring word was there. Then, Learned Advocate General highlighted that this particular neighboring has been deleted subsequently. But the entire thing as it stands was that any vice chancellor may not be of a neighboring university, but of the university has to be appointed.
That's it.
So that is staring at your face, and now they have cancelled that appointment of this head of the department. He has been removed from a post of a vice chancellor, so it again remained vacant. Now they have to take report. What they will do. Okay.
But we have already amended that provision. We have restored the old one because
It has gone.
no, we are going to do it. Not now. I told them we have to wait till this case is over.
What remains then? Nothing.
Infructuous,
remains.
sir. That's already.
My lord, my grievance is repressed.
That's all. That's all it says.
Yes, ma'am.
It's already.
Nothing remains.
Nothing remains, it's fine.
We start being a competition.
I'm from opposite part number 3, in charge by
Oh, your name will be recorded for good reason, don't worry.
He is worried that she will not,
we will
she will
definitely
not there
record, don't
since
worry.
yesterday. Don't worry.
Your interest would be sufficiently protected.
Item 6.
May pardon, my lord, I am on business. Beg apology for that. Last occasion, this also directed the State Council to take instruction mandate in the matter and to file response.
Yes, what is this? Why
Yes.
not?
My lord. Next step.
This is that case where you have stopped the mining operation by an order. And they could not operate mining activities or the mining scheme. And you charged the full royalty for that. Now he wanted that this royalty which you have charged for a period where I was restrained from operating to be adjusted for the next future year, future period, so that when you permitted them to start the mining activities. Is it that case?
My lord,
Here, the royalty that was charged for the period where he did not work, that he already paid. That
Correct.
royalty he has paid. He
Correct.
wants adjustment
Adjustment
of that
in the
royalty
future,
for future 25-26.
because this is that if it is a voluntary act of a miner, I mean the mining person, not to excavate, then the authorities cannot be settled because they have already permitted.
Yes.
If the authorities have restrained him from doing it, then why he should be penalized? Authorities cannot blow hot and cold at the same time.
That is why I want to bring it to your lordship's notice. Certain provisions of the statute. Your lordship may kindly see. Item, your lordship may kindly see Rule 32(3).
Yes.
of the Orissa Minor Mineral
no.
Concession Rule 2016.
16,
Mal
30,
32. 32.
yes, sir.
Liability for payment of royalty.
That is there.
Yes.
Is upon them. No difficulty.
No, my lord, he.
Read.
It is
All the lessees of a minor minerals
Yes.
shall be liable to pay the royalty or a dead rent,
Yes.
surface rent, additional charges, amount of contribution payable to the district mineral foundations, amount of contribution payable to the environmental management fund, and fees for compulsory
Yes.
afforestation.
My lord, kindly see 3.
In addition to the surface and dead rent, as the case may be, is liable to pay the additional charges, amount of contribution payable to the such and such foundation, and contribution payable to the engineer. That is already there in one.
Yes.
On annual basis, on a minimum guaranteed quantity of the minor minerals. If
but
the
he
actual
has been-
extraction falls short of that. So you say that even if you have extracted less, you have to pay.
Well, what he has been charged for 2021, 2026 is the advance royalty and DMF and other things.
Sir, probably you do not understand what their case is.
I have understood, my
No,
lordship.
you are avoiding.
But-
The question is, when you refer this Rule 32, this Rule 32 is very clear that you can charge those royalties and other, and I may say, emoluments in advance. There is no difficulty. He says that I paid those for the previous year in advance. But if I have paid for the whole of the year, then I am expected to excavate or do the mining activities for whole of the year. I was prevented, rather restrained by the authority not to do the mining activities for a considerable period of time.
There is the crux, my lord. Whether he was prevented or.
So that's order of restraint. You have said that, where is the order of restraint, sir? If I correctly remember,
Your lordship may
Madam,
kindly say
they rejected my
29(4).
transit pass, madam.
where is
The
that order?
transit pass- We are applying for transit pass. Order is that at page 32, madam. Annex 5,
32.
madam, where the CS, State Environment Assessment Authority directed to revise the mining plan.
Yes.
Yes.
Thereafter, the authority rejected my transit pass application, madam.
Yes. Modified environment clearance was to be given by the state impact assessment authority. He
And
approached.
where is that? Where is that transit pass?
44, my lord. Page 44, my lord. My transit pass application rejected, my lord. Page 43, my lord. 11/2023. Page 43. Annex 9, my lord. Status rejected. I have been prevented since 11th October 2023, my lord. That, my lord, that is a tabular form, my lord. Page 43. Transaction number applied, number of consignment, status rejected.
What is this 43?
Page 43, this is a transit pass application approved by the authority for excavating sand and movement of the sand.
So,
That on 9th October they have allowed, on 11th October they have rejected. Thereafter I have been prevented to operate this query.
yes.
Well, why he was prevented, you may kindly see. Your lordship may kindly see 29(4) provision, my lord, of the rules. 29(4).
Correct.
The lessee shall be responsible for obtaining environment clearance and implementing the environment management plan. It is the
Yes.
responsibility of the lessee.
Correct.
So since he could not produce, because his amendment plan was pending before the SIA authorities, but he could not produce that plan. He could not produce the amended plan. So that is why, because it is a precondition to get the permit to run the query. But lease, obviously lease continues. But to operate the query, the permission, it is a precondition to have this.
Why you allowed him the lease? If it is a precondition to a grant of a lease, then how can you execute a lease without
Well,
that particular
when
requisite
lease-
conditions to come?
When lease was granted,
Yes.
he had the EC.
Correct.
Then subsequently, when it was found that where he is to operate is nearer to the bridge and there is a restricted area.
When you started and then gave, did you not realize that it is nearer to a bridge?
So, my lord, he has operated.
He was operating on the basis of a EC clearance.
My lord, he operated from 21, 22, 22, 23, 23, 24.
True.
Then subsequently, because EC, he has to get it renewed from the state assessment authority.
Correct.
They raised objection that it is within that periphery parameter.
After 3 years,
Yes, my lord.
they become wise.
He filed an application for amendment. So his application for amendment was kept pending. So, my lord,
What was the duration of a lease given to him?
that is
5 years, madam.
5 years. 5 years.
I have
So
up
he
to
could run only for 3 years.
Yes, 3 years he has run.
So, and there was no objection.
3 years, my lord, that objection was not raised by the state assessment authority.
Oh, I understand, sir. When for 3 years in respect of a same mining activities, there was no objection. Suddenly one fine morning, one wake up and then say that now why is the problem? What is the problem which which existed at the day when the mining applications were sought?
CR authorities, they have to answer.
That is what is, who is for the CR authorities?
Yeah, my lord,
You are responsible, you have prevented, you want everything to be done.
my lord, the mining officer, your lordship may kindly appreciate, the mining officer has to work within the parameters of the statute.
Sir, I
once it is a
understand,
precondition-
sir, I understand the same. When you find that, please kindly visualize the situation. We are more on equitable principles.
Right.
We are more on equitable principles. Look at the situations. I do not know, in the midst of the lease, some objection is raised. And that objection relates to a situation which was prevalent at the time of granting the lease. It's not that something new has come in the meantime. The bridge was already there when you granted the lease. Is it?
Yes.
So, EC did not raise any objections. But you say that no, EC clearance is not there, I will not permit you to
No, my lord, he
go on a
he
point.
applied for modification of that.
Oh, I
That was kept
understand. I do
pending.
not know what.
So once every year,
there
unless
is
he
a
gets
English
the,
proverb.
but unless he gets the clearance, so what the
Like
mining
Dr.
officer will do?
Sikilja did with a normal podium, I would have said.
Can I pray one thing, madam? Now that the mining officer, whatever notice has been issued, demand notice has been issued, that is by mining officer in accordance with the provisions of the statute.
I will not relegate him to go and take a decision by the mining officer.
No, not by the mining officer. And any conditions of the statute that can only be relaxed by the state government. That is as per the provisions of the statute. So let him approach the state government, let them take a decision whether it can be done or otherwise.
It's not really necessary.
Or
It's not
otherwise-
necessary. It is not that we will record that what has happened, the entire scenario, and on equitable principles, whether the action can be justified.
Because there is no provision. Mining officer cannot go for adjustment unless and until it is either the provisions of the statute are relaxed or he gets an instruction from the higher up authorities under the provisions of the Act. Now, if he feels aggrieved by the order passed by the mining officer,
Is there any better on the part of the writ court to pass an order?
regarding,
Mining officer cannot do it, somebody cannot do it, writ courts are not.
but the order, if he feels aggrieved by the order of the mining officer, he can, under the provisions of the statute, the mechanism is made, he can prefer an appeal before the
Is there
deputy
any
director
absolute
mines.
bar in entertaining to put this?
No. That is not absolute bar, but when a mechanism is there, so let him approach the authorities. Let the authorities take a decision.
We are not concerned with the decision. We definitely concerned with the decision-making process. That's a very settled fundamental principles of exercising the power under Article 2 conditions. If we find that the decision cannot stand or withstand on the reasonability test, we not. Which is one of the paramount consideration to declare any provision as autonomous. Visualize to that extent. Reasonability test is embraced in our judicial system.
Equity can supplement,
It's
but it
not-
cannot
it's not
supplant
one way
the
traffic.
provisions of the
No, no.
statute. Madam.
What? If the provision is silent, can you visualize the situation?
Yes.
Had there been an express provision debarring such thing, then definitely equity cannot be done, he owes the law. When there is a complete vacuum, nothing has said, this way or that way, cannot the court.
Then if my lord should pass that order, but I cannot stand on the way. Your lordship can pass that order. Only if your lordship allows me to put the submissions on affidavit before the court and thereafter if your lordship, so that I just.
You wanted a ventilation to be given, ventilators to be.
Because the mining officer has not exceeded his jurisdiction, he has worked within the parameter of the statute. Yes, so he is a officer down the hierarchy. What he can do?
But we are talking to you. What is this? Kindly visualize the situation. He is neither here nor there. Just imagine.
Only 24-25 is the period where he could not operate because of the restriction.
But he paid the entire advance money in terms of.
Because that is a precondition for grant of permit.
So
It is a
you cannot
precondition.
blame him that he has not complied.
And every year the mining officer has to raise the demand because the statute mandates. So, Lordship, may allow me to put that all my submissions on affidavit before, because they, otherwise, I will, let me put on affidavit, your Lordship, pass that order. Just grant me some 2 weeks time so that I can put everything on affidavit. So,
This one.
they are represented, that is OP number 8. They are represented.
They are represented by who?
They are represented by their own council, panel of.
Whether the notice has been given to him?
No,
Notice has not been issued.
no,
Not issued.
not.
Not issued.
Issue a notice and come back, we will seek you.
But
And in the meantime, you file your affidavit.
but
You file your affidavit.
we will find.
Anyhow.
Notice to, I will take notice to my lord, OP number 8, my lord.
See, there are two line of judgments. One propagates what you say, and the one propagates what they say. The line of judgment is that so far as Calcutta judgment I know, I can share with you, that goes in their favor. The Calcutta view is that was in relation to a Kolkata Municipal Corporation Act, where every owner of the land or a person responsible for payment of the land revenue is supposed to deposit. It contains a provision for variation or enhancement of the tax that's called a municipal tax on a periodical basis. There is a provision to challenge. So the enhancement was done on a different parameters for several years. Large money was deposited. Ultimately, it went to the High Court. High Court quashed that order of the municipal commissioner. And it appears that there was a substantial amount lying with the corporation, which he paid in excess in terms of those demands. Then a writ was filed for refund of that excess amount from the municipal corporation. Then the question arose that if there is no provision in the municipal act for refund, then whether the court can pass an order to refund.
In my case, my lord, due to the change in law, my lord, change in law, the change by the mining plan, what they have may operate for a larger area, they have granted the environment clearance. On the basis of that environment clearance, I have paid in advance. The advance money paid to this is an unjust enrichment to the government. On their assurance.
Whatever, let them file an affidavit. So I gave you, you just find out those judges.
My lord, I will answer, my lord.
Please find out.
My lord.
Call the next.
Item 7.
Item
7.
In this case, I have challenged the finalization tender in favor of opposite party number 4 without any intimation, but without conducting lottery in presence of the petitioner. Last occasion,
You also applied.
I also applied, my lord. Date was fixed, date was extended from time to time, and ultimately the date from which it was fixed, lottery didn't happen. Thereafter, they, without intimacy, they fixed another date and made it final by conducting lottery in the absence of the petitioner. Last occasion, your lordship directed them to find
Oh.
him.
10/6 is the date.
Last occasion.
His brother.
His brother, yes,
Yes, he
that
is
was,
his
that
brother.
was, yes.
I have taken instruction. that
This
both-
Abhijit Bose or something, if I
Abhijit
correctly.
Bose.
My humble sir.
Now I remember.
Yes, my lord. I have taken instruction in the meantime. In fact, no notice was issued to the present.
I am asking whether your brother was
My,
there.
my lord, my-
Is your brother?
Yes, my lord. That instruction I have taken. Why? Taking the instruction, information went there, his signature was obtained. But in the process of lottery, the deed of the petitioner farm was not included. He was not allowed to participate in the lottery. That is the instruction, madam.
What is the relation? What is the interest of the brother to go there?
He got the information that they are going to.
Why will go? There are many brothers who are not in the helm of affair of his elder brother. Why he will go?
And locality, small place, my lord.
What are you talking about, sir?
But my lord, my humble sir.
If a brother is not interested in his brother's affair, why he will go? What is the charm?
But he was
He'll
not-
say, I am not interested, I'm not going. Unless the brother requests him to go,
my lord,
he will not go.
my lord,
And
but-
if he is instructed to go, then he represents you. If he represents you, you can't say that no notice was given.
That is one part, my lord. The other part is the bid of the present petitioner farm was not included in the lottery. He was not allowed to participate in the lottery.
Junk which was kept. I do not know how the lottery is conducted.
Lottery was,
Must be a voluminous documents there and
yes, my lord.
randomly pick one.
Yes, my lord. That is the process. In the process, my lord, the farm of the petitioner.
How do you know that it was not included? You were not intimated of the date. You never represented. How you know that your paper was not included?
What instruction?
Sorry?
What instruction I have received, my lord?
Under section 102 of the old Evidence Act, onus lies on you. One who asserts have to prove.
My lord, no notice was issued.
But your brother represented, that shows that there was a notice to him
No.
or notice to you.
Your lordship last occasion directed the state council to produce if such notice was ever issued or not.
Not necessary. Anyhow, you disown that particular name.
My lord.
On the last occasion, you disowned. That's why we say that produce the document. Now today you are coming that yes, he is my brother.
He's my brother.
And you are saying that yes, after receiving an information, he went. Has he applied separately?
No, my lord.
Then why a person who does not have any interest will go unless he has an interest, brother?
Now, getting the information, he went there.
Why he will go? Please consider this.
My lord,
Either I know you know the answer, but you are pretending not to give an answer.
My lord, my.
Why a person will go unless he has some interest
He
or
has it.
instructed? Somebody
has-
instructed, you go there, then he will go. Otherwise, he will not go. Why he'll go?
He had that.
Is it
they're doing
probable?
Secretly, he had that they're doing it secretly without intimating anybody. That is why he went there. And no, they have not been able to produce whether any notice was issued to all the participants or not.
No, none of the participants have come forward except you.
My lord, my
Their instruction is they produce that document, I think.
letter.
No.
Last, you produced a document of.
A bunch.
Yes, my lords. And today's instruction, my lords, the video himself stated he personally called Mr. Rahul Ghosh and told him that the meeting is going to be held on 10/6, and he told that his brother will attend in the meeting. That
His statement.
That is your statement and his statement. Which one has to be valued?
No, only
It is an oath versus oath. You want him to come on oath.
or what?
Do you want him to come on oath? Then he will produce the mobile, the details that he called you on your mobile phone. CDR, call detail report. And if it appears that it's the falsehood, we will go for a perjury and against your client, send it for a criminal trial to be sent in jail. We'll send.
When they were
I
regularly.
think earlier IPC is 192 or 195 section. We'll recommend the initiation of the proceedings against you if we find that your client is not truthful.
But I will not. Well, I
Not
will withdraw my.
We will call him.
Madam,
Do it.
I will withdraw my case.
No, don't
If
withdraw.
you say that the.
File your affidavit.
Madam,
It's closing on oath. We will see to it.
Madam,
If
the
this is
deed
there.
is included. If you are not. if
Whatever,
you-
sir, let them come. Let them come.
I have-
Just give. If you have the screenshot of that number also,
the video recording is also there.
video recording.
Yes.
The entire
So then
process.
you
Entire
give.
process.
Then what
My
transfer
case
is?
is letter was issued. That is my case. Limited.
The one was
That is-
9/6 letter is addressed to all of them.
No letter was issued.
If your lordship permits me to submit,
I will
why
withdraw
is
it.
repeating the, I don't know, last instruction they had submitted before your lordship. It has been clearly mentioned, accordingly, all the bidders were present on the date fixed. The committee scrutinized the bids and found that 3 numbers of bidders were disqualified due to non-submission of experience certificate for which it was rejected earlier. And 2 numbers of bidders were found qualified for the work development of mini stadium such and such. He did not qualify because
That is my.
experience certificate he did not give.
But
It
that
was
is
raised
my
to 5
case.
crores.
That is my case.
It was raised to 5 crores. That experience certificate come. So that he did not give. So the initial bid was rejected. The technical bid he failed.
But he was shortlisted. He was called to lottery ballot in 2 to 3 occasions. If you are not qualified, what prompted them to?
What the lottery will do in this case?
In fact, that is a wrong terminology used.
That is what I am talking about.
Wrong it was for 9/6 letter to all.
For evaluation of the financial bid, that who has quoted what? Is it?
Technical bid was held on the 10/6. After technical bid, 2 persons were found responsible for which minor lottery was held. As they are quoted the same rate.
Same rate. Okay.
Yes.
Well, total 10 bidders were there. 5 were shortlisted. They were issued letter under unanimous ballot to participate in the process of lottery.
Gradually at the bar.
There has been irregularities.
There it is one of the classical example With? How much? This is what I'm saying. With, I stopped. How much? How much? What?
The cost, then I will.
Yes.
Now, just by last order, the Union of India was to take instruction on Annexure 8, page 8, 121, 181. Sir.
Yes. Where is anybody representing? DLG? Yes. Yes, sir. What is, have you taken instruction?
My lord, we have not received instruction yet. So more time may be granted. Already we wrote a letter. So more time is required. Nursing give another 10 days time.
Now, since there is an ongoing recruitment process going on, and that may be concluded by the end of this month. I filed an IA to stay the proceedings.
Well, it is a continuous process, not that everything is done very suddenly.
It's 2 weeks' time on the prayer of the DLG.
Item 9.
Yes.
What? Oh. Same.
Item 10.
To involve here is almost similar to the earlier cases with retrospective license, page 19.
What?
Page 19, Milord, a license issued with retrospective effect. Lordship are considering other matters also. Kindly see page 19. The facts are little different here. 8/5/2015, they are issuing license with effect from 1st of April 20.
8?
Lordship may see page 20.
Yes.
License date is 8/5/2025.
Yes.
Just see page 19.
I'm just at 8.5.
Right, but that's at the bottom.
Where at the bottom?
At the bottom of this page.
Bottom of the
This page 20.
20, yes.
Lordship will take about 8.
And validity is from 1st April.
Right. Retrospective. Now, there are actually, this is little different to other matters. But here, they closed my shop without complying with Section 26, saying that some allegations are against me with regard to having some goods, some backer. But those allegations are there. One SIP was run against me. SIP in the sake of the charge. Now, they closed down my shop. I approached it. But this one also issued a notice. After issuing notice, they closed it on 7/2. They closed my shop on 7/2. These are the 4-5 dates are there. If they closed it on 7/2, after receiving notice, they opened it on 10th.
10th May.
10th of March.
March.
25. It continued up to 31st of March 20. Now, during this period, they imposed a fine of 2,71,000 against me to compound this. Am I clear, madam? 2,70,000. I'm sorry. In fact, on 7, suddenly,
Of 25.
of 20,
Yes.
7/2/25, they closed down my shop.
Okay.
They have drawn one allegation against me that there are certain unauthorized things inside my sub premises.
That's a on-shop
This
license.
is a OS shop. OS means outsteel shop, made out of Magua. This
Oh. Country liquor.
country.
Yes.
Now they closed on 7/2. They have drawn a charge sheet against me. Now I challenge the charge sheet for this one. But I have that order. This honorable court was pleased to issue a notice. After issuing notice, they opened my shop. On 10/3, 7/2 to 10.
Correct.
They opened my shop on 10th. It continued up to 31st of March. 10/3 to 31st of March. In between, pursuant to that charge sheet which they have drawn against me, they imposed a fine of 2,70,000 against me. Now that 2,70,000 was challenged before my lords.
Okay.
My lords would kindly see page 50. Kindly see. Page 57. I'm sorry. I'm so sorry. Page 57. My lord's order.
Yes.
My lords, considering rule 68, in fact, this is rule 68, para 3, or you may see page 57.
Yes.
Considering rule 68, read with section 75, your lordships took a view that you cannot impose a fine more than 50,000.
Yes.
And your lordship modified that fine from 2,71,000 to 50.
Because the statute provides the maximum limit of 50,000.
So great. That's the consideration before my lords.
Correct.
Now, after your lordship's order, I paid the amount. I also paid the renewal fee, whatever they are required to be paid. Now they issued me the license on 8/5. So from 31/3/25 till 8/5, they got me the license. Shop remained closed. They did not issue me the license on the basis of this wrong demand, which your lordship ultimately modified to 50,000. So that period, they have included with retrospective effect in the license.
But what the rule says that it has to be according to the financial year or
It's your lordship, that it says, so does the definition in the rules, your lordship. It's a financial year, your lordship.
where is the provision?
Excellent.
Which provision?
But in fact, I will be relying on section 35, lordship please. But we have seen it earlier also. But they can realize fees and duty only against a license. Nothing prior to the license.
No, there are two aspects of life. One has to understand that. One is the charging or granting of permissions, and one is for the computation of a period of a license. Granting of a license and computation for period of a license are two different concepts. This period is really for computation of the period.
Yes. When your lordship is asking me a question, what can be the period of a license?
So period for computation, it may come from a retrospective effect.
Lordship, sir, actually, period of a license, it is for the authority. For what period they will grant me a license? It's necessarily not 1 year. They can give me for 3 months. They can give me for but up to 3 months. That is there. So it necessarily need not be 1 year. What they have done is those closure period.
Where is the provision for this? The tenure and the duration?
Tenure is there.
Then can you say year is.
In fact, there is a judgment passed by this service. A license cannot be with retrospective.
Oh.
Well, Lakshmi period also it's here. I can show my lord.
Do I get that provision?
I'll just show it to you. Yes.
Which one?
Check rules.
Your Lordship will see.
Rules, definitions, rule 2, definitions. Says that a year means the financial year.
Section 45 before that, Your Lordship.
Where is the correspondence? Show us that one.
Can you see section 45?
Section
25, section 45.
period as may be prescribed.
Then rule 23 is the best.
And then rule 23.
Here it is a.
No, may be granted for any number of years, not exceeding. So it
First,
has to be yearly. It has to be yearly.
No, there is no minimum prescribed anyway. It has to be for 1 year. No.
And it says that it's beginning from 1st April.
Yes, ma'am.
And your lordship,
So-
it says that if any license granted at the time of 1st April, it shall be granted only up to 31st March the next year.
There is no dispute about that. But Your Lordship will see. Necessarily, even if
And a year means the financial year, as defined in the.
but then necessarily, even if you have closed down my shop, you will grant a license for that period to me because I will operate.
No, it was closed down. It was, if I correct, it was closed down by virtue of whatever. That was previous financial years. And then on immediately within, after 1 month, immediate after the expiry of 1 month, 10th March, they permitted you to continue. So you continued up to 31st of March. There was no restraint order nor a prohibitory order against you. Now you can ask for a renewal. There is no difficulty. So that renewal would take effect from the 1st April.
Right.
And if they have done it, maybe a belatedly 8-5.
Right.
I do not know here the excise rules there that so long the decision is not taken under the excise rules,
Deemed.
deemed
No, deemed.
renewal.
That I'm sure. Deeming is not.
Excise rules, it says deeming. Deemed.
That deeming aspect is not. Both of us can agree over that.
Because it has to be.
Yes, so much. This is pertaining to revenue.
That is why I am aware of a Bengal excise rules where the provision is there. There is specific provision. It says that it will be deemed if the authority has not prohibited or passed an order and an application for renewal is pending before it, then deeming provision is that it will be deemed to have been renewed until that order cancelling that.
Yes, the Lordship says that an application for renewal is given has to be from the day it was applied for. The Lordship, there my
Renewal must precede the date of expiry of the period of the license.
That here is.
So that should be, it must be filed prior to 31st of March.
That in fact, that should be, right? That's the policy also. But
That it has
here
to be
they-
filed so that the authority will take a decision, and so long that time is consumed, it will be deemed that it is renewed.
But
And
the
so
question-
that uninterrupted
Absolutely correct.
seamless session
Here they-
for the purpose of collection of
Absolutely
the.
correct. Here they closed it down. So I had no, they didn't apply even for renewal.
That was closed in the previous financial
So
year.
this year also.
This year is the only problem. What you are saying is that as per the rules, since they did not pass an order of renewal on 1st of April. So there is a deeming provision that you cannot operate. I understand, sir, you wanted to say. And your right to operate originated from 8/5 to 25.
So great.
I understood that. So that there is, that's why I'm saying that there, the deeming provision says that there should not be any closure. You will continue as it's a deemed renewal for such period.
Yes,
And it will take from a retrospective date,
Yes.
continue.
yes. Yes.
What come back? Has to be.
There is.
Otherwise,
Penalty
the
pending.
problem is, I tell you,
If there was a penalty pending, your lordship, that might have taken. I have to seek instructions to that.
the senior counsel has come. The problem is that the law does not permit us to issue a mandamus upon the state to legislate or bring amendment. No, we can't.
Can I
We
just
can't.
once?
Mallikarjun judgment of the Supreme Court, you know, in a very clear terms, the Supreme Court says that the under Article 226, High Court cannot direct what to legislate and what not to legislate.
You know,
We simply,
Yes.
we can interpret, we simply recommend that this is the gray area.
yes.
It should be considered by them, but we can't issue a mandamus to do that.
Why the license was not given?
And my learned friend sees this judgment.
The difficulty
It seems there was a penalty pending, your lordship.
Mr. Madam, the difficulty is, that a person cannot be settled for a wrong being committed by an authority. If you chose on 8/5 that the license has to be renewed, it comes within the peripheral. Then in that event, there is no difficulty. Then you can't take an advantage that I will not charge the revenue for that particular point. I understand that what you will say. You will say that there was already a subsisting demand against it. The authorities have finally passed an order saying that 2 lakh something is due. Unless you pay off, I will not renew a license. They challenged it. This amount was reduced to 50,000. They immediately complies.
Yes.
And that was in the month of April,
Yes.
back end of April. The moment they deposited 50,000, then there is no dues. You immediately proceeded and issued the license or renewed the license.
If you would have imposed 50,000, probably this
So
would
the-
have.
What it appears that the action of the authority was in contravention to
Yes.
the law. Can an authority take advantage of his wrong? The court held that you are wrong. You have transgressed your authority beyond the statutory provision. That was the conscious decision taken by the court. The shortfall. It's 1 month or some days.
200 considerable period.
1 month or some days, sir.
1 month
8th
or some-
May and 1st April.
Absolutely.
So 1 month, some days.
But today, since my learned friend is asking.
Why don't you sit together and
That can be done. You are-
finish it off?
Yes.
I'll seek instruction from the department, actually. But that's what.
Whatever the shortfall, They will do it. They will make up. There's no
But
difficulty.
collector has power.
Revenue's interest is protected.
Collector has
Take care
power
of-
on section 100, rule 151. Collector has power of adjustment of issue. Collect,
So section 151 and rule 151.
rule 150.
151 of the CPC, inherent
Inherent.
power. And rule
Inherent.
151.
Yeah, rule 150. In fact, my learned friend also took take note of this judgment. We are at the further view.
Where is that judgment?
Here I will give it.
Which paragraph?
But para 12, concluding part, internal page 4, bottom 2 lines.
Para
Internal
12.
page 4, para 12, bottom 2 lines. We are further of the view that the excise authority cannot raise a demand for a period prior to issue of license, since it is well set in law that licensing obligation will commence the date of issue of license and conditions imposed there.
No, that was a case where the apex court in a public interest litigation under Article 32 imposed the restrictions of any foreign liquor shop to operate within 500 meters of the national highway. So on the basis of that order judgment,
Actually,
all the
shops remain
shops
closed.
were closed and they were forced to close, though there was no fault, nothing of that kind on their part. So in that event says that during that period you can't.
I think that was not the case here. It was closed. This is not closed on a.
So it was a case of a demand of either MPQ or a consideration money. That was a case.
National highway issue is there. National highway issue is there in this data.
Lordship, 6th of August.
Number 6.
Without requesting for a formal review model. I am not requesting for a formal review model. I am just requesting my lord, my learned friend. Let them instruct not to take it.
I will.
That's it.
No, you are operating still.
Right.
On
Let
the
us close it down again. Only
Definitely.
my request, my learned friend.
basis.
So grateful.
Item 11.
Lord.
Notice was issued.
What are the provisions of the Odisha Minor Mineral Concession Rules 2000? You say that tender is violative of. Can you show?
I challenge the tender on the ground. That's
Sir, will have give us a translated copy, sir. We don't know the tender. Tender is floated.
it is both in vernacular as well as in English.
Where is the English version?
It is
Because you have
very
annexed at page 17.
Milord.
This is all a vernacular.
Yes, Milord, there are
Oh,
two. In
9-6. Okay.
Milord, Lords will see.
No, I got. Page 19.
Yes, page 19, thus the immediately translated copy of that vernacular. There, your Lordship will find,
What are the conditions which is violative of the rules?
Milord, your Lordship will find there are 6 sources, Milord, at page 20, Milord.
Correct.
Milord, these 20 sources are put to action
Khodra.
at district Khordha, Milord, in different villages. These properties, your Lordship will get the khata number, plot number, it is recorded in the same.
Correct. We have seen the Mauza, Khata number and the plot number and Kisam
And the area also.
area also. Yes.
This area, your Lordship may kindly mark the first
Serial number 4.
Milord, the serial number 1 and 2.
1 and 2.
Milord. It is, your Lordship will get it in acre.
Yes. 1.087.
1.087, 1.01, and then your Lordship will turn to serial number 4.
24.89.
Milord. So the one of my ground of challenge is that in Deepak Kumar case, the apex court has said that less than 5 hectares cannot be put to us. That I will take lawsuits later.
Less than 5 hectares cannot be put to?
Action. Look, this is less than 5 hectares. All these three sources are shown to a lawsuit. Only the serial number 5, 6, and 3. That is more than 5. I'm sorry, Lord. 5 hectares means 12.35 acres means. So only
Only one,
serial number 3 qualifies.
Yes, then
Lord, that is one of the ground, but the main ground of my challenge, my Lord, Lordship may see, I've given the ROR, the record of right, your Lordship will get it. It's in a vernacular, but your Lordship will, that it is recorded in the name of Lord Sri Jagannath.
what recorded in the name of?
Lord Sri Jagannath.
Acha, Lord CG.
Milord, that is an act where under Sri Jagannath Temple Act, before putting any transferring any property either by way of lease, sale, or whatever needs be, prior permission of the state is absolutely necessary. Lord, so kindly 716(3).
Which one is recorded? All the 6 properties?
All the sources.
6 properties?
Yes.
Where you have pleaded?
Milord,
In your petition?
Yes, Milord. Your Lordship may kindly turn to my paragraph.
Yes. Paragraph 1 also.
7, Milord.
1 also you have pleaded.
Yes, 1 I have this listed, Milord. 6 and 7 I have stated, Milord. That it is recorded in the name of Sri Jagannath Temple. That is an administration, Milord. That is a statutory word. And there,
yes.
Before,
Yeah, where is the provision of that particular act?
Milord, Sri Jagannath Temple Act.
Yes, please.
1955, my Lord, your Lordship may kindly have a glance, section 60.
Section?
1(6).
Yes.
Alienation of temple properties. Lord, there are 2 acts, your Lordship may see. 55 Act.
Yes.
Milord, subsection 2 of section 60. Save as otherwise expressly provided in this act, no immovable property taken.
No. You're reading section 16.
16, subsection 2.
Yes.
Milord, subsection 2, Milord, save as otherwise expressly provided in this act, no immovable property taken.
Anyhow, this is absolute bar.
Yes.
Yes, absolute bar.
Your Lordship may say, previous sanction of the state.
Yes, I accept. Then,
Milord, here it is the minor minerals. Your Lordship may kindly visualize.
yes.
It is put to action. I was an intended tender. The tender condition shows that the successful bidder must obtain consent to operate, environment clearance, and also formalities after it is declared. Here, since the property belong to not belonging to the state, belonging to some.
Why you participate?
I have not participated. I have challenged. I have challenged there.
That's the main ground that these properties belong to Lord Jagannath by virtue of this Temple Act. Nobody can sell or lease or mortgage any property of the Lord Jagannath without the prior sanction of the government. That's the only one of the point or a main point?
One of the
points.
Apex Court decision, Deepak Kumar case, less than 5.
So is it not mutually destructive?
Not mutually destructive.
That's true. That means that less than 5 hectares, they cannot go for an open tender. They could have granted it. That means they can grant.
No, Milord, that they can.
So first point is the only point that they cannot lease out.
Yes.
That's the point.
Yes.
Second point is in alternative mutually destructive. That they can do it Auction, they can be done, that can be done, but below 5 hectares, they cannot do auction.
My submission before your lordship.
Sir, please consider. What you are saying, consider. I'm just inviting your attention.
My submission before your lordship.
Chose. It's a doctrine of election. Chose which one?
Yes, Millard.
First or a second?
Millard,
Tell us. It's your choice. Elect.
Millard, even if I elect Millard, I elect the first one.
First. Let us take an answer. Yes. How can it be done? If it is recorded in the name of, then in that event, by virtue of this order, can you deal with the problem?
Instructed that NOC was right. See the letter of the.
No, is NOC by whom? The
state
statute does not say that NOC from this. Statute says that the prior sanction of the state government. So show us the sanction which was accorded.
Can't
Can't be.
if it can be taken up by the crime, what is
The previous sanction of the state government. Where is the previous sanction before this? Tomorrow as the first matter, you just show.
Item 12.
Out of same action notice lordship related to tomorrow at first case lordship.
You have taken out of this case.
That's it, but.
Have you taken out that this land belongs to Lord Jagannath?
No, I have,
You have not taken.
but I have taken lordship more grounds. In another.
Have you enclosed the ROR?
Lordship, I have enclosed the error.
What ROR says? Standing in whose name?
Page 61 lordship.
You can read, we both of us cannot. So tell us.
That is also lordship. I have taken more ground lordship. It is
What is there?
objection. It is a gochur land lordship. I have taken
It's a gochur land.
Gochur land. It also cannot be. It is also not permissible under the Ujjalis Act.
So it is not Lord Jagannath.
Lordship. That is there. Lordship.
So the gochur land, then the different act applies.
Yes, lordship. That is also.
Where is that act?
Ujjalis Act lordship, section 3. It prevents lordship the state government not to either to leisure or to make any construction or make any.
Just
act
to
of
us.
that.
Which one?
Ujjalis Act, section 3 lordship.
Section? Rule 3.
Rule 3, lordship. Sorry, rule 3. And provide a lordship.
Oh, Rule 3 does not really prohibits. What are you reading? Gochar land?
What's prohibits lordship? No construction, no.
No. Says about the
Rule 3 of the Ujjalis lordship.
No, Rule 3 does not talk
Provide
about the
a
gochar land. I'm just gochar. Give him a copy. Give him. Please look at where is the. This is the fact. They're talking about rules. You're talking about act or a rule?
Rules.
Specification about the gochar. Since the urban land, blotting of the urban land, that would be civil limits is. Which one?
Act lordship, rule 3 provides a lordship.
What provide? Oh, you are talking about act, sir.
Act, sir. Sorry.
You have taken us to rule.
No, in fact, lordship. Sorry, I'm extremely sorry. I was telling about act.
Yes, madam.
The things I've already asked them. How do you say?
Okay. These are the government has to be reserved. On the prayer, 1 week. 1 week.
Procedural penal interruption. They're going to settle the action.
This matter is
They will not.
not participated in my lord.
Yes.
They have raised a very pertinent questions.
We take it tomorrow.
Tomorrow? Come tomorrow. We don't mind. Come tomorrow.
We was election, they had fixed for action.
Maybe we'll see to it.
Item 13.
Your Lordship, I did look into the order dated 9th July 2025. Your Lordship has directed to take instruction.
Yes.
This is an appeal. Your Lordship has been rejected on the ground of delay. On the ground of delay, the appeal has been rejected. And there was a CBIC circular, Your Lordship, a conditional circular issued by the CBIC that if you deposit 5%, 10% and added 2.5%, you deposit your Lordship, then by 31st January 2024, then the delay will be condoned. So it is a condition. So he has filed, admittedly, he has filed the appeal and delay. Your Lordship, he has not taken the point that that circular, the benefit. And that notice has been sought to the dealer and he has not complied. Hence, the appeal has been rejected on the ground of delay. Now, Your Lordship, my instruction, paragraph 6, Your Lordship, page 2. Paragraph 6, Your Lordship has directly, you are directed to verify whether the 19th March 2024, the later show cause notice has been issued and sought to the dealer or not. Your Lordship, this has been issued and served through portal. And the portal service is a valid service as per section 169(1).
We have also said.
Your Lordship,
Yes.
Your Lordship has categorically three judgment. Your Lordship has categorically here. So the due date, I have enclosed also the circular in the last page, Your Lordship, page 6. Page 6, the circular, CBIC circular, where it has been categorically held at paragraph 2.
What is the date?
31st January 2020. So the deposit, why, Your Lordship, it cannot be extended, it may not be extended.
I am
Because
asking the date of the circular where
the circular
further
date is
conditions
2nd
have been-
November. The circular date is 2nd November 2023 at page 6. And the due date is at paragraph 2. That is 31st January 2024. The has to be filed or the amount has to be deposited. Why the amount has been deposited? Your Lordship, because in GST, Your Lordship, as per section 107, no appeal shall be filed unless so and so. So when shall be filed, the pre-deposit is mandatory. And this particular paragraph 2, that 31st January 2024, hence the deposit is to be done by that 31st January 2020. Since not deposited, then he is not eligible. The benefit as for this subject.
what is the power of the High Court under Article 226?
Your Lordship, if this will be extended, Your Lordship, because this is a circular, restricting circular, Your
I
Lordship.
understand
Restriction circular.
that one can, when,
Everybody will
that-
come, Your Lordship.
if I,
And there will be no-
if I use the very bar, time for a period.
Your Lordship.
We use my bar.
Your Lordship.
If it pays 2%, right?
Your Lordship, but that is a condition. My dated so and so. Whether if that condition is to be restricted.
Statutory requirement is that 10%.
10%.
Prove by the circular that if you pay additional 2%,
Then the delay will.
then the delay will be controlled automatically for consideration.
So we are waiting another, the petitioners are waiting another circular to come to condone all the PFC.
Now then you will take, those circulars
No,
are applicable to a pending appeal.
No, Your Lordship.
All the appeal which is dismissed will not be advantage, then you will argue.
No. It will be applicable by to the pending appeal by dated so and so. It has been dismissed 31st 10/2024 at a later date.
Yes, circular.
That we cannot expect. So let him approach the tribunal. As your lordship is granted liberty to go to tribunal by depositing 10%. So let it be pending for tribunal and let
40% is supposed to pay 10%.
your lordship not particularly 2% because he has to deposit.
If he deposit, he has already deposited 10%.
Your lordship.
He has to be, which he failed. So now, had he deposited more percent within 31st March,
Your lordship.
then the delay would have been controlled.
Your lordship.
Right? So since he failed to deposit 2%,
Your lordship.
now he is forced to deposit 10% to avail that remedy of travel.
Obviously. Because
To suffer for 8%.
because the rejection, but because it is his obligation, your lordship. Because it is his obligation.
Which are already there, and they are always take note of this. It's not only knowledge, it's a knowledge matter. In fact, it is knowledge. What you are doing. What you were doing. Not by somebody else. This is a very important one. Gives you a complete respite that there would not be any consideration on the ground of sufficiency of the cost. Automatic consideration. That's why I use that word. If you have knowledge, it would have paid what to do. Natural justice.
%10 order.
I know it. And you also know. We have kept all those matters, I think, for when it is coming.
You're 24.
Submit alternative, my lord, and submit a Calcutta High Court division bench decision in similar issue, my lord. In the delay on fee. So.
Oh, that is pending before Supreme Court.
Justice Sivakarno is judgment.
My lord.
Justice Sivakarno is judgment.
My lord.
That is pending before the Supreme Court. I am submitting just.
Yes, my lord.
Sivakarno's judgment.
Yes, my lord. Do not it is order, my lord.
Whatever.
It's a, my lord, in the intra court appeal, my lord.
Okay, SK Chakravarti judgment. Honorable Supreme Court has stayed your next.
This is the Muhammad Sikandar. He is the line.
Your Lordship, this judgment has been stayed by Honorable Supreme Court. That is SK Chakravarti case. Your Lordship may kindly go to the order of Honorable Supreme Court. The stay has been granted. SK Chakravarti, your Lordship might have remembered that Calcutta judgment. It is Calcutta. Well, we have already granted show cause notice and admittedly he has not deposited. Admittedly, he has not deposited. Yes.
Not on the issue of on the delay, my lord. Had he deposit 2% more,
2.5.
there cannot be any demand of a show cause or something.
Your Lordship. Your
Now he is put into a more trouble. Now you say the entire demand is now recoverable because your appeal is dismissed.
Lordship.
Now he has to pay 10%, then also the demand will remain in suspended.
Your Lordship. Suspend.
Do one thing, what do you do? Pay the 10%, what do you do?
Well, since
We decided what to do. Pay 10%.
I'll pay 10%, but if the matter will
If
be.
we deposit 10% first, we have kept this matter, all matters will decide it. Because the tribunal is not there. You have a statutory right to go to a tribunal and challenge the order of the appellate authority. And the law says that you have to deposit 10%, so you deposit 10%.
Now cannot condone the delay, my lord. The fact is that it is not a condonable. Delay cannot be condoned, my lord.
Then the question would be when an outer cap is provided in the statute, whether the court can or authority can control delay beyond that.
No, my lord, the court cannot, but similar in this behavior also, the court remanded
That is all 226 past. How far the Supreme Court has already stated. What to do?
Recently, Your Lordship is also passed the judgment.
He is always taking advantage of how judgment is done. He never takes advantage of a good judgment.
Your Lordship, how can Your Lordship has passed that judgment by recognizing many judgment upon Supreme Court as well as coordinate bench. Your Lordship, okay.
Deposit 10%.
As you record, I will deposit 10% and after the attachment it will remain
Suspended.
attachment is already made, my lord, and it's 3.
Which one?
And it's
If you
3.
deposit and come down, we will remove the attachment.
Well,
No.
Assessment was made on section 143 of the Income Tax Act, against which appeal was filed. That's petitioner also filed an application under 220 subsection 6 not to take in default grant and relying upon CBT
Before the assessing officer itself.
minus 20% CBT has directed that in all cases where appeal is pending, you are required to pay 20. Even if your lordship knows in AG electronic case, confirmed by Anu Apex Court saying that 20% doesn't act as fetter, despite of all that, 20% direction is there, now 20% comes to 27,07,645. Plus I paid about 16,91,000. And then I moved an application. That's why moving an application for the balance amount, whatever I have paid, again 20% I have directed to pay Viras. Then I paid 6,77,000. Then what has happened in the process? Because refund was due
Still shortfall.
of 3 lakhs. What has been done? Refund for several periods was due to the assessee Viras in respect of other periods. What the assessing officer did,
You wanted the adjustment of those.
exactly. That's for one. He has made several adjustments. He didn't stop from one. He made adjustment even if without complying 245 lordship have seen. The other day, your lordship asked my friend to take instruction because by several adjustments which he has made from out of the refundable amount due to the petitioner. Because total, let me quantify Viras. Total demand is 1,35. 20% comes to 27 lakhs. Whereas he has in the last order which he has passed says that now the balance is 86 lakhs. So I have made a calculation that in the meantime total payment and recovery by way of adjustment made is 87,000. 48 lakhs 15,000 total amount paid in lieu of 27 lakhs only. So 21 lakhs is the amount which is taken excess. That Honorable Delhi High Court in several judgments and has directly refund along with applicable interest periods. So Lordship directly friend take instruction on this. That is the point.
In this case, I have got the instruction. Party instruction has been received. So Lordship, I need 1 week time to get fully. And Lordship, I can explain it is not a fault of the department. Adjusted this amount.
Fault.
No, there is no fault of the department.
It is if it appears from both documents that for the several preceding financial years or assessment years, there is a refund which is to be made.
Yes.
And if the fact remains that the refund has not been processed, that means the amount which he is legally entitled to receive is withheld by you for a period. Now what he says is that when for a particular assessment year, you have raised a demand. Under section 143, you have made the assessment orders and the assessment order says this. And then they have to go for an appeal. That's a right which is already provided under the. Now, 220 because the assessing officer will proceed for attachment. So they have to go approach the assessing officer. Now CPTT circulars are there, which says that they have to deposit 20% of the amount. So they are ready to, they say that I am ready to deposit 20%. I am depositing this much of cash and this is available to you. So that will be deemed to have been deposited by me. And those amounts should also be adjusted and it appears that you are holding more than the 20% of the total demand. So they want that this excess amount you should refund with interest. Interesting.
Even section 245 says either whole or any part of the amount. Supposing my balance 3 lakh remains and my refund for a particular period is 8 lakhs. So you can't adjust 8 lakhs. You can even adjust part of the amount to appropriate 20% Milos. But what they did Milos, they went on.
What will happen?
They didn't stop there.
What will happen if the appellate authority reject your demand of 1 crore remains? Yes, tribunal, ITAT, tribunal also affirms. Then second appeal before us, last no substantial question of law. Then
no. Your question is Milos. Pending appeal Milos. 20% and
yes, take instructions and come back after the week. This petition was filed since April, Lords. Copy served not since April. I tell you, last occasion, my lords reminded him take instruction at least within 1 week. Sir, the other day, I called the individual. They say that there should be some mechanism which should come into this. Because I have been since the day I took over that there is a very unique way of submission that this matter has been listed for the first time. Give me an opportunity to pay this. Even if that service was affected 3 months before. Correct. But listing for the first time, that encourages the adjournment. So I say, why not? Immediately the brief is to be allotted the moment you receive the copy. And then it's the responsibility of the appearing counsel to take instruction. Absolutely. So whenever the matter is listed after 1 month or 2 months, whatever, at least he's equipped with all his, he can make the submissions. That would avoid, sometimes the disposal can be made on the admissions. Directly.
Item.
But I mean, the very unique, very confusing manner, what I find is that the state holds the brief like a musical chair. He is allotted a brief for a day. Tomorrow, if he is not available, then brief is allotted to somebody else to argue.
Forward this item.
Item number 15.
Leading to non-constitutional GST government. Non-constitutional GST government. Non-constitutional GST.
10%. Yes.
Make it legal action.
Yes.
My lord, the matter involves service tax.
Service tax.
And identical matters, my lord, are pending before this honorable court for consideration.
What is the point?
One each, my lord. One each. I am sending you the this order. My lord. The points are to be examined only after the London Council for the Revenue files a reply.
So
Whether these are tenable or not, my lord, these are many cases pending. So I humbly pray that your lordship may take this matter, so that it could be. And in the meantime, no question may just be. I have already paid, my lord, actually. They didn't take it into consideration. Your lordship may take some matters to this case.
Yes.
Which order? There is no such order. Lord, I think
This is the Kotak Automobiles matter. Which is
the 74-4B, but kindly say there is no such order and I'm not able to find out what is the order.
This is what I also.
But he is enclosed on corrigendum order. That is what the problem. He could have enclosed the order.
Give him a copy.
You are right. I think. But there is, Millard, I know that there is so many pending, but which order he has and that don't know.
He's this annexure 9, 8, 10 and.
Yes, annexure 9 is a corrigendum.
No.
So the original order is not there.
Why you are not assigning the original order?
Annexure 9, you will copy of the order dated 10/5/23.
Right.
And thereafter, they have to receive a recovery notice. These are my humble submission that this order is appealable. I have to submit. But on the well recognized principle that not been afforded with a reasonable opportunity of being heard. After submitting the records on some document I submitted, but due to my bad luck, my lord, my authorized representative, that's a record, he met with an accident, and my father, who was an advocate in Sambalpur of age about 84 years, he was admitted for severe stomach treatment and operation in Ernakulam, Kerala. So I was there for 2 months. I could not appear, my lord. So now they have issued that tax and penalty 20 and tax is 18 lakh. And my case, specific case is that, Lord, I have entered it also. I have already paid tax of 14 lakh some odds, and the difference amount, Lord, for that I have not received the amount. So if my learned friend will file a reply, my lord, all these points, if the lordship may consider, or alternatively, your lordship may please excuse me to give some time and condone delay to go into appeal. Let him, my learned friend, definitely.
Must be not. But he's correctly somebody. I am not. The original order is not there. If your lordship.
Where is the original order? Please.
There is a
Where is
provision.
the original order?
My lord,
These are all
this is the order of
consequential
Article 9.
orders. These are all consequential order to the original order.
Right.
So if we do not challenge the original order, whether consequential orders are susceptible to be interfered with, tell me, sir. Look at the thing.
My lord,
Take time, look at the thing and do something.
I have some problem. I can speak, but I have some hearing problem. That is the whole problem.
Tell him.
I am facing this.
Tell him. Tell him.
So, my lord, your lordship, give some time.
Please,
I will
please.
You time देते अपन time नहीं किया सिलेक्ट
I'm additional happy to be.
original order brought into the record.
Original order.
It is a original order.
Original provision.
Original order ଅଛି ଆପଣ ଆଉ ଗୋଟେ order ଟେ file କରନ୍ତୁ file କରନ୍ତୁ.
Thank
Oh,
you.
yes, my lord. This is original to order. Your lordship is asking the
What is what
original.
he is saying?
I will ask my client.
Yes, sir.
Correct. So take time, how much?
After 1 week.
On the prayer of the president, let this matter be listed after. Yes.
Item 17.
This matter is pertaining to section 73 for weak finance act. Correct.
You have checked that?
Yes,
So it's for the other side. You have checked? Yes. You have seen?
Yes. The matter was listed before Supreme Court, that matter.
What has happened? So they were supposed to pass an order yesterday, we were told.
No, it is adjourned to 26th of August. This is the case. This is the case.
तू बोलेगा तो हमें देखिएगा कल.
The matter was not taken up.
There is no order available in the website. I have checked in the morning.
Keep it. Yes.
Item number 18.
That item number 18, my lord. That I should fairly concede before the lordship or judgment passed by the honorable single judge is correct, because the Sanjeev Builders case is staring at me. The lordship may pass order without recording my person. Malad, it is there, Malad. How can I say that I have
You have
not?
to be bold enough to say. You have to be bold enough to say.
Yes, Malad.
You are-
I know the judgment, Malad. I had been arguing these cases.
Then why you accepted the brief and filed the appeal?
Malad, if I would not have filed, some other else would have. Malad, why should I lose a brief before your lordship? Because
Quite a very fair submission.
Give me that.
Malad, it is
You appreciate a very fairness that has been shown. Very.
Malad, it is there. It has been quoted by the honorable single judge at page 19, if your lordship may kindly see. Which is not there, Malad. How can I? Why should I disturb your lordship?
No.
Grateful.
I am appearing for the response. My appearance is to be recorded. If you remember, what's my Bakalakam already been Bakalakam has already system is different. There only the slip is to be given. Lordship.
Item 19.
Item 19, Your Lordships, we are on caveat. Not a single copy of it has been given to me. This matter had come last time. And in fact, I have forwarded.
Got instructions copy has been submitted to Mr. Mahanti because he was there on that day.
Has not been given.
I was there. My caveat is there, and I was the lead counsel arguing that matter.
Mr. Mahanti was there, and we have submitted on the same day. We have solved the copy.
You've not given me a single copy. I have been waiting. And Your Lordship,
The batch of cases.
there are other batches of cases we have forwarded.
Madam, somebody by the name of Pratyashis Mohanty has filed the caveat. And they say that they have served the copy on him.
No, they haven't, Your Lordships. He is an associate from my office. Yes, Your Lordships. And in fact, Your Lordships,
He's saying that it has not been served.
Quarrel about this. There are other.
As per my instruction, my lord, copy was served on the same day.
May I be permitted? WA number 1109 of 2045.
The other cases were given.
On 18/7, my lords, a copy was served.
Your Lordships,
When she's saying it has not
No,
been.
I don't dispute that. I don't dispute. There are large number. There are number of associates, number of advocates are there, my lord. Certainly, my lord, I will solve a copy on that.
I was the lead senior counsel who was arguing that matter, and all of them know it. A copy has not been served upon my office. I'm there on caveat.
Yes, Ms. Roth, the learned senior counsel appears and submits that the copy of the writ appeal has not been served upon his client, upon her client.
I have to obviously defend a writ appeal which is there on the list, and I deserve a copy.
Some matters which have not been listed, they're giving the copy.
In course of the hearing, it transpires. In course of the hearing, it transpires that against the self-same judgment and order, several appeals have been filed, which are pending before.
No, one more prayer in the sense that it will be convenient for the hearing of the matter. The concerned writ hasn't come, Your Lordships. I was checking the list. The main writ in all the pleadings were there.
So all these matters would come on 6th, we'll see.
6th, yes.
Yes.
Ma'am.
Item number 20.
Withdrawal. Any interim order you got? No. Nothing. Yes. Withdrawal. Correct. He's asking for withdrawal. Do you have any objection?
No, ma'am.
No. Withdrawal.
Item 21. One.
Nobody's here?
But also for withdrawal. MO is there for withdrawal.
Who is the advocate in the court?
Mr. D. Mahapatra, Debidatta Mahapatra is not there. Mr. Debidatta Mahapatra.
Anybody knows Mr. Devidatta Mahapatra? Nobody knows him.
From the office of Mr. Dulti Padi.
Do you know, madam? Can you contact so that he comes? He wanted to withdraw. We will permit the withdrawal. Only thing is his presence is required.
Yes.
Yes, the mobile number is also given. I think here he can give him
Yes.
a mobile number. Give her.
Give me back.
Yes, take a mobile number and just make a contact.
Match. Item 21. Sorry, item 22.
Who?
We have a Parvin Swarup.
Arvind Saru.
Parvin Swarup.
Parveen Saru.
Kindly take this matter next.
What has happened to him? Or her? I do not know. On the last occasion, you did not appear.
In my advocate on record, Supreme Court is inconvenient, that's why it comes. Next.
Advocate in record, where he is?
Supreme Court. There is a inconvenient, that's his record.
At the expense of his matter in the High Court. Adjourn for a week.
Another rate appeal is there connected, 1049 may be listed, so that.
No, we don't know. What is this?
Item 23.
Okay.
IA number 1947 of 2025, therefore, filing the certificate of dispensing with the filing certificate. In fact, I have applied for.
Have you applied within the time?
But I have applied. I have applied.
The time of within time means within the period of limitation. Have you applied for certified copy within the period of limitation?
No.
Outside the period of limitation? Then dispensation is difficult for me.
But in fact, the certified copy was filed. For the single judge in the review application, director, I could not have.
No, you have to file a certified copy of the impugned judgment. So how can you file it before the single bench?
Review.
Oh, this is against the order review. So you are challenging the review order or parent order?
Original order.
After the review is dismissed.
Yes. And that is why last year, Lordship, my lord, allowed the interim application for condonation of delay. And another I have applied for certificate.
You were pursued. Now they wanted a dispensation. So obtain the certified copy and file it. Yes. This is an application seeking dispensation of filing the certified copy. Yes, sir.
I pray, kindly allow me to submit the reply response to the appeal. I make an affidavit reply affidavit. Because it is not relating to terminal benefits.
Sir, I appreciate, have they relied upon any new document in the appeal?
No, perhaps are more important than procedure of.
Then you must have filed the writ petition,
Yes,
writ
we
petition. So we will depend, this is the continuation of the list, we will depend upon that unnecessarily.
Instead of the writ petition.
For some good benefit, you want to file opposition, counter affidavit,
No,
then
no, my.
after a week.
My brother only keep writ petition, whatever I have given.
Oh, that has been, the High Court is a court of record, sir, under Article 215. You can, there is no difficulty. No difficulty.
Fix up the.
We'll consider the point
Fix up the date on 14th.
after, on the prayer of the applicant. Next week.
Why not?
Item.
49th or 30th. Next date.
30th.
Oh, it is already fixed on 30th, sir.
Item 24.
Nation. Yes.
And finally reply to the IEA. Paying for condemnation of delay.
How much days delay?
21 days. 121 days.
Last final for is also dictated order regarding condemnation of delay.
Dictated order? No. You are confused. In some other matter where you appeared, I dictated. Not in this matter. So, would you like?
Normally I don't.
File, counter to us affidavit within a week. File it within a week. Matter to appear next week, after 10 days.
Common judgment, in common judgment, they.
We will allow, sir. That's a valuable right has accrued because of your act. So how can you deprive him?
May I agree, another same, out of same judgment matter, 1261 of.
We'll see. Condonation has to be considered first. Don't worry. Just remind us. We will pass the order. Don't worry.
That can be.
Oh, both. But then he will say that I must file a counter there.
Will tag matter, then one common judgment.
Condonation cannot be tagged. It depends upon the facts of each case.
Item number 25.
Pardon the lordship, I need instructions in this matter will be granted by you.
This matter is pending for a pretty long time.
4 matters, the recent is for the same and these your lordship, and the recent one is the last case your lordship. That is Vincent Dalai your lordship. I would seek time because in each of those cases your lordship, some the last total bench asked for some instructions which are not there your lordship.
There are 4 matters. Different sources are involved. First matter is a different source. Last matter is another source. So you lordship may take up the first matter.
Lordship, I need some time. I have to seek some instructions.
Convince them.
You also can see the order, last order, Miller. There was a direction to the Tahsildar, Miller, to produce the document, Miller, with affidavit, Miller.
Here, my lord, I am appealing to the opposite party number 7. Here, the entire.
See to her prayer. If you are agreeing, then we will reject the prayer for adjournment.
No, it was heard and the order was reserved. Subsequently, it was released from the blood.
My lord, can see order that
this matter was heard at length.
By whom? By whom?
Coordinate bench of this honorable court.
But both of us had no opportunity.
Correct.
So
we had also note of submission also on record.
Last order on 14/5/2020, your lordship. It was said that the learned AGA shall produce the proof service of the letter dated 3/12/20, your lordship, by annexure A4 to the petitioner. So I need some instructions, your lordship. I need
My lord, this order is not required to be complied with because in view of the previous order passed by this honorable court. My lord, Can see the
So you are opposing the prayer for adjournment.
because that is not required for
No,
because
he is
suppose-
opposing.
Your Lordship, the order is from the bench, a coordinate bench, Your Lordship.
Because suppose tomorrow this order is compliant and affidavit is filed, the petitioner is not going to get any relief. That is what my endeavor is to
I will
praise my
get
lords.
only leaflets. I will get same.
Because my lord, I turn to page 24 is prayer made in the repetition.
Well, in his date, he there's that question, and after hearing Lord, order is passed, Lord. It has been hard for
copy of the
7 to 8 days,
IEO
8 times, Lord. There, the same question always, Lord, at the beginning, Lord. And your Lordship, after hearing the case on merit, Lord, then pass the orders, Lord. Your Lordship, last order, Your Lordship, can see, Lord. And that clinches the order, Lord. Entire issue, Lord. The cancellation order has not been communicated to me, Lord. That is the.
You are representing whom?
OP number 7.
Who is he?
Well,
Who is he? Private or the government?
no, private.
So what do you say? She's asking that she want to comply this direction. For that she wants. If the court has directed certain compliance to be made,
To be compliant.
whether it is irrelevant or relevant, we do not know.
This matter has come to me for the first time, Your Lordship. So,
Because of the faulty system which is prevalent.
first with the coordinate bench, Your Lordship, from the first time, I would have. I can feel it somewhere.
That order,
Yes, on the prayer of M.R.PATHAK, that a week's time is required to comply the order dated 19th,
14/5, Your Lordship, 14/5/2025.
14/5/2025. So, list the matter after a week, just give 30th, 31st.
Item 26.
What is the outcome of that particular discussion with the RD department?
Has been closed, Your Lordship, the contract. Without any penalty.
What is the challenge which they have made in the instant writ petition?
They wanted for closure, they have prayed for a closure of the contract because it could not be
They
started.
want now their prayer is allowed.
No, but I had challenged Lordship the decision proposal. Without doing so, Lordship, by your suppression of facts, Lordship, they have did it, Lordship.
What is your prayer? Let us see.
Lordship can listen, Lordship.
What is your prayer?
The Lordship may see, it has been written in the.
Yes,
closure.
yes,
The
it is
18th
there
Amendment
that it should be declared without authority contrary to the term with further direction to close the contract in respect of this.
Lordship.
Correct. Now they have closed the contract.
Because of
And they have not imposed any penalty or.
Lordship, because Lordship kindly see, because this officer, without disclosing that they have recommended for a closure of proposal, because of their fault, Lordship, or could not be completed. Without doing so, Lordship, because Lordship kindly see that.
If it is a closure of you also wanted a closure of the contract so that you cannot be saddled with any kind of a penalty or thing for unfinished work. Now they have decided to close it as you prayed and do not want to impose any penalty on you.
Lordship, in fact, because Lordship kindly see, this is the contract of Lordship kindly see.
This is a contract of a road, construction of a road from Barani to Chandrabil.
Lordship.
This was there.
There, Lordship, because without forest clearance, Lordship.
Oh, true. Now they have closed it, that they do not want.
No, only my humble submission, I was praying for that, Lordship, because it is not possible to work out, Lordship.
Correct.
Because now, Lordship, kindly see, they kept my 70 lakhs rupees for quite long period, and because of their fault, Lordship, now, Lordship, after Lordship, kindly
Now, once they have closed the contract, they will pay back whatever. Yes, they will pay back.
And Lordship, what I am bringing, Lordship, kindly notice, Lordship, is only one point, Lordship, because I definitely, Lordship, I will get the money and I will go for Lordship compensation.
So,
But Lordship, here Lordship, one thing Lordship, because I just was going to Lordship judgment Lordship, because here Lordship, suppression of material facts, only that is the only reason Lordship. For that reason Lordship, this matter Lordship took a quite long period, and because the Lordship intervened several times, last they are going to take this decision Lordship, decision final. And Lordship, my humble submission Lordship, because of fault of this officer, Lordship can see one thing Lordship can see, because Lordship can see, now they have admitted, Lordship can come to Annex 16 per more Lordship. Internal page 7, 4/7 the 14 document Lordship. Relying upon this document, they come with disclosure proposal, Annex 16. Internal page 7 of my Lordship, my reply to counter affidavit Lordship, that is Annex 16, 4/7 done 24 Lordship per month.
Their prayer is that you could close the contract and whatever the amount I have already deposited as a security, performance security. That interested in the ultimate relief or interested in chasing them?
No, Lordship, not that.
So your prayer is there, and they will release your performance guarantee. There is no difficulty.
That is my entire endeavor for Lordship. I have not done it.
So that is what is.
No, Lordship, what I only one line, I need one line, Lordship, one line observation, Lordship. One line observation, Lordship. Can you see why this matter, legal Lordship, why Lordship?
Record is saying a withdrawal.
Item 21.
Maybe 40 minutes.
Yeah.
Item 27.
Then your Lordship, I need to file a counter affidavit when it's standing.
Already filed by you. You are representing who? Counter is 53. Also. Yes.
54, your Lordship, counter is filed for the state pollution.
No, the already. The 54 is a private company. And OP2.
I'm sorry, your Lordship, another case. Sorry.
That means you are not in the matter.
No, your Lordship.
Then who is in the matter?
Yesterday it was 27. Sorry.
Who is in the matter? Mr. L.
Earlier he was there.
Then who is? At that time he was the AG. Right now there is a change.
Yes, sir.
Somebody new person will come.
27.
27. Are you?
That is assigned to me that, but the record is expressed on that. I will pray for tomorrow. Tomorrow. The problem is. Next week.
28.
28 Mala, it's a PIL Mala regarding non-filing of vacancy, a member of Lokayuk body of Lokayuk. Well, on the last occasions, if you lordship should counter affidavit page number.
What I intended to say before my conference started, because she is for the petitioner, she has got pre-audience, that we are agreement signed. As a matter of fact, the young AG wants to address your lawsuit. Since some cases your lawsuit are posted to 4th of August, you also wanted the presence of AG. 3 days back only. 4th August, he is going to address your lawsuit in certain why the posting remains vacant? When the AG wants to address, will not be fair on my part.
4th August.
Yes, ma'am.
Keeping 4th August, you are taking on.
September 29, there are 4 matters. One matter we have received the Paris comments. So we'll file the counter and we'll adapt to other cases. We'll examine it necessary. We'll just ignore and the same counter will be adapted.
What matter you received this?
It is item number sub-item 10326 of 2025. They have paid.
By the accountants, they are right.
Lordships, item 1 and 2, it's 8 months and filing the contract.
No,
They wanted to use this counter and use it in all the matters. They will not separately find the counter. This is performance. It's submitted by the interpreter. He is the we can grant you a liberty here and now.
Yes, sir, Lordship, I'll.
It goes without saying. The sheet of the copy of the contract.
I pray one thing, this same matter I mentioned to. Other matter issue notice, then in this case, my lord, I received the instruction, but there is notice being issued.
Then this is the matter after.
Yes.
After 3 weeks.
Yes. Item 30.
Let's do that.
Item 30, my lords, I pray for a short adjournment on behalf of my senior. He is having some health issue today, not be able to appear.
I'll not stand in the way, my lord. I'll not stand in the way, my lord, but I would pray, my lord, if the matter is taken up next week, any day, the top of what has happened. I am appearing for opposite party number 11. I am the L1. Now for
If the thing. She will be available next week.
My lord, he will be available. Month.
31st.
31st, next week.
kindly, my lord, wait top of the list so that it reaches. Or my lord, may grant me liberty, I will make a mention.
Even before the top of our names, this
Hold
got more talk. We'll take up.
Item 31.
Did you?
Let's remember that he's a alone person. I think with the conglomeration of so much of the citizens, Union of India.
Just the PIL fight for the missing of the state of India. Therefore, India filed the counter stating that they take the all necessary steps to remove the misuse. But I am stating, I filed to the rejoinder to stating that they step already served your losses. And it is under 5 year losses.
Part-time submission.
Your lordships, meanwhile, let me complete your lordships. Thereafter, whatever demand, I will see submit.
His facial expression suggests something else. So I believe that that has to be hard fast. Because your energy should not go wasted.
Part-time submitting. Last occasion I submitted about the judgment of Karnataka High Court. Recently they have given the Calcutta High Court judgment. Comparing all the two judgments, I have read it, but I have not prepared this way. But only thing is that the Karnataka High Court is elaborately examining all these things and given some guidelines. So on the next date, if anything suggestion is there from both sides given, it is a very sensitive issue. So this we all should consult about this. The emblem should not be misused or nothing should be wrong. So what they are suggesting and
he's citing your
Your lordships,
your side.
Your lordships, I appreciate the medical it's not in my side, in the side of the nations. I humbly submit that your lordships in 2008, Kamal Dev versus Union of India filed in the Kolkata High Court, your lordships. I get a order of that from the Ministry of Home, where it is passed on the contempt applications arising out of that petition.
What's the issue, sir? Don't go what Calcutta did.
Your lordships, issue is that on that time, the Union of India is setting that we take the actions. Now
What
also,
action? We do not know what action. You tell me what is that? What you really wanted? You wanted implementation of certain things. What is that thing? You wanted the
your lordships, I wanted that the common people are not aware about the facts. Therefore, I wanted.
What is the fact?
The fact is that your lordships, if
you have read the brief whole line yesterday, we have not. Please tell us the fact. I do not know what fact.
Your lordships, the fact is that in somewhere the Satyameva Jayate was the motto of the national emblem is not written that in some fact where is the.
That is that means you want that in some conspicuous public places.
Yes.
The word Satyameva Jayate has not been written.
Yes.
Yes. Or it is it's embedded or enforced. What? What do you want? You want everywhere should be there.
Your lordships, we are not established the national emblem everywhere. We have the specific place as per the rule 8 of State Emblem Rule 2007. We established in a specific place.
Correct.
Except that we annex some documents here.
That they are using it some other place
where is the restricted? Yes, your lordships.
That is what. The fact. We do not know.
And now they stating in their counters, they rectify that the written in the Satyameva Jayate on that place. But in your lordships, if we go to the Rule 10(2) of State Emblem Act 2007, Yes, your lordships, I have the judgment of the Kerala High Court on that. Yes, your lordships, it's the mistake. On that ground, your lordships, I bring the judgment of the Kerala High Court. It is a mistake, not only here, your lordships. I looking that in the before of the judges, before of the old chief court and chief court, old building 4, 1, 2, 3. I have been the lordships, Kerala High Court. Your chambers? No, I should not use here, lordships. And in Kerala High Court, the lordships in 2008, same things happened. The High Court is directed.
He says that the truth must triumph. That's the motto of Satyam Jayatu. So that he says that he has seen the judgment of the Kerala, he has seen the judgment of the Kerala High Court. So he wanted to ponder upon the thing, then wanted to adjust on the proposition of law. If it is forbidden under the particular rules, they can't. They are the rule making power. They have a rule making power. They cannot defy their own rules. No difficulty. So when you can come.
That can really get I am very precise. If they have enlightened about the misuse of the emblem. So immediately I brought to the notice of the secretary, even though earlier they have given many circular, till then they issue a circular to the chief secretary. And the concerns it should be taken very strictly. And if any sort of misuse is there, immediately action should be taken. All precaution has been taken by the ministry on this issue. And apart from this, the rules are spread out in the nation. Somebody has violated. The rules is there to take action against them. So we are remind anybody or any authority that you not take any action.
He wanted that to ensure the strict implementation of those rules.
That is already been done. Already I have filed the affidavit and saying they are in there.
When, if you are ready, then we
can give after 10 days. Any day.
Take me, both of you.
Anything. I may keep it to.
Give me a date, both of you. Give those judgments.
Your lordship, it is not judgment, it is a development recently happened. It is the letter of Ministry of Home Affairs.
Yes, when sir?
It is the 18 July, your lordship, the petition received on 20th. Your lordship regarding the.
Nothing, they have simply said look into the matter.
Your lordship, just I explained what is the letter and what is the mistakes of this letter. I just explained.
When
Let's give it to 12, 13, 14, any August.
Which date is suitable to you?
Your lordship, 1 minute I can explain the letter, your lordship. It is the not mistake of the state.
Sir, I really appreciate. Right? This is why he's asking for an employment. You will exhaust your energy. I will appreciate it. Listen to me. Can we dispose of pass an order because he's asking for it? I'm asking this. This is what I'm asking. He says that he has gone through, he wanted to ponder upon the things, he wanted to look at the law, he has not prepared himself on the proposition of laws. Though he's saying that the rules are there, he cannot defy the rules, there is nothing which can be defined. But still, he wanted to have, because you have flagged an issue. Will you tell me the date, his date is
Let's give it 13th, 12th.
Whatever that should. Work will do.
Yes.
But we will keep this matter as.
Yes. We'll conclude on that.
Basically fixed matter.
Yes, yes. We'll conclude on 12.
It's a very interesting issue that is raised. We wanted to hear.
Well, my lord's guidance will be implemented to all.
No, that's true.
Yes. Because if anything is left and is not taken care of by the Karnataka High Court, you can take care of Lordship path yesterday.
So that where the 180 days period of portal was blocked, I filed application for unblocking. But in the meantime, your lordship, they have to, the lordship are direct to take instruction twice, but now they have blacklisted me, so for the same project action, so yes, sir, my lord, I filing amendment today itself. File, my lord. It is not along with I am serving the copy of IA2 IS, my lord. That is 1, 2, 3, 5, 7.
You filed it first. We are saying
already filed. Already, my lord, on the today file, my lord. Number
is here.
Yes, ma'am.
It is submitted by the Contractual officer that during the witnessing of the instant petition.
May I please look? This is the case, my lord. The petitioner difficulty, my lord, here is a gift, the project allotted to the petitioner, your lordship. Your lordship, kindly see the order dated, your lordship's order. Lordship order date 27 January 2025. While your lordship, please issue notice.
Say the.
Sorry, my lord.
We thought, let's say this form.
Sorry, lordship. Yes,
I get confused when your lordship's part is.
Yes, the lordship. Your lordship.
No,
Dear Lord, this honorable court please to issue notice. My lord, I am permitted to place a lordship.
Yes, that is that Jones.
Plant
instruction for demonstrating that the relevant provision in the agreement was subject to.
Yes, Lord.
Guidelines being formulated in future.
Your lordships kindly see the agreement, your lordship. The counter affidavit, your lordship. Flag A, your lordships.
Yes.
Paragraph 11, your lordships. Page 4, paragraph 4. Yes. That as regards to abutment in paragraph 11, it is humbly submitted. The petitioner was paid previously towards price adjustment rupees 2 crores 55 lakhs 15,273, and the remaining amount based on the tentative calculation of price adjustment an amount of rupees 8 crores 26 lakhs 61,190. The tentative cost of price adjustment will be paid only after formulation of phase guideline on price adjustment under due to reason mentioned serial number 10 says that, your lordships, this is a contract, my lord. They have paid the price escalation part of this under the same clause. Your lordship, they approved my price escalation, quantified the amount under annexure 1. They say it will be as per the, my lord, future guideline, which is not part of the contract, my lord. Your lordship, kindly up to the, my lord, the annexure 1, your lordships. 1, page 19, your lordship. This is a brief.
Yes.
Your lordship, kindly, this is the, my lord, the subject 4. This is the approval of the government of the is a bridge work which is completed, my lord, because length was increased, my lord, is satisfactorily completed with benefit of price escalation. Your lordship, last line, my lord, clause 2, your lordships, page 20, my lord. The payment of price escalation shall be made after necessary verification, admissibly at the end of concerned R&B.
Formulation of a guidelines on they talk about it, the price adjustment.
Your lordship, my humble contention with your lordships, there is already modality the quantified in the agreement, that is page 43, Lord, annexure 4, and they have paid the first, Lord, the part of it, Lord. Now the future guideline is not my contract.
Annexure 4,
Lord, page, your lordships, page 43, Lord.
40?
43, your lordships. Your lordship, this is the they have relied the office memorandum circular dated 24 December 2012. Your lordships, the clause, your lordships, the provides next 31A, your lordships. 31AI, your lordships. If the reimbursement of recovery due to variation in price of material other than the steel cement between, if during the first word, if during progress, my lord, then your lordships, the next clause, my lord, in 1, 2, 3, 4, fifth line, your lordships. Fifth paragraph, your lordships. Price adjustment, increase or decrease in cost material other than the cement between pipes and contracts shall be paid in accordance with the formula, my lord. Fifth paragraph, your lordships.
Yes, I got it.
Yes, Lord. Your lordship, my lord, my lord, in respect of labor also, your lordship kindly found out page 45, your lordship. As per the modalities formula enumerated in the agreement, my lord. My lord, your lordship, that is also page 45, your lordship. What now, my lord, they are saying that the circular which was before your lordship, the circular in some other case contractor association was they have under they relied a judgment of decayed infrastructure in counter affidavit. They annexed that judgment. But that judgment also, my lord, speaks no circular can be implemented, my lord, retrospectively. Thus, this contrary, your lordship, that judgment that is annexure C by 6, page 13, your lordship, which also come from of counter affidavit.
Sure.
Annexure C by 6, counter affidavit, your lordship. Lordship says the relevant paragraph. C by 6, your lordship. Page 13, your lordship. One thing. Flag is, your lordship, flag is.
My lord.
Counter affidavit.
Yes.
Lordship, this judgment they relied, my lord, your lordship, but rather this judgment, your lordships, I pray for your lordship to paragraph 23, 22 and 23. Page 42 and 43, your lordships. These judgments say it cannot be retrospectively applied.
2 point.
Paragraph 22, your lordship. The judgment page is 30, your lordship. May I permit, please?
Yes.
Your lordship, paragraph 23, your lordship. Again, my lord, troubling, your lordship. Paragraph 23, your lordship. That in view of the above fact and law, sorry.
Yes.
Your lordship.
So that was a different case. It is
Exactly.
that suppose in the future, if some office memorandum or the new model is provided for the purpose of determining the quantum of the on the score of price escalation, that will not, because it will tantamount to varying the main original contract. This cannot be done unilaterally.
It is a conflict of melody, your lordships. I am relying one page of your lordship.
So according to you, the day when the contract was entered into, 2012 circular was prevalent. And therefore, you abide by that 2012 circular. You cannot keep the entire thing in abeyance because you are going to formulate a future.
This and this is a part of the contract, Miller, and it has been exercised in during course of work, Miller. And this and the Miller, a conclude contract, you cannot reopen this, Miller, and rewrite the
Concluded contract.
Miller, concluded contract. And your lordship, that is my
Wherever a judgment cannot vary the terms of a contract is unilaterally.
Yes, it's similar that I go to the political. This is my and here my admittedly 2022 the price escalation approved under Annex 7 Miller with Miller that you yes, lordships. Paragraph 21, 23. Yes, lordships. The lordship paragraph 21, that is page number I have not marking it. So paragraph 21 is page 184, lordships. It's arising out of an insurance contract.
21 is nothing.
Therefore, the terms of contract had to be constituted strictly without altering the nature of the contract.
It's different. While construing the contract, it is. I'm talking the variation, novation, and or modification based on one party, unilateral.
The para 23 verses. After the completion, here the work is completed. After the completion of contract, no material alteration can be made in terms of except by mutual consent.
Yes.
Your lordship, sorry, that's Miller. And your lordship, the and same your lordship, the another Miller, I am submitting my Miller, the brief your lordship, Annex 6. They have approved with escalation. Now your lordship, page 95, your lordship, page 95. And it's a big project. Annex 6, your lordship.
Yeah.
And this is the government order, Miller. The government, after careful consideration, have been pleased to approve the EOT up to 31st March 2022 for the aforesaid work in favor of so and so superclass control with benefit of price escalation adjustment up to 31st March 2022. And you paid the part amount, Miller, and the remaining future adjustment, Miller. I am also on a company, Miller. I am suffering very lot, Miller, paying interest. This is my difficulty, Miller.
Still, you are continuing with the construction.
No, Miller.
Or you have completed the file.
No, he is completed, Miller. Completion certificate, your lordship, Annex 5. Annex 31st March 2022, I completed, Miller. I am, Miller, but my pay escalation has been not been paid.
Yes.
Similar, this Miller. So once the amount is quantified and partly paid, you cannot the paid that in future guideline of rest amount. Miller. This amount, Miller, your lordship, then after conclude contract, you cannot reopen, Miller. And the second principle, Miller, subject to lordship, this is a principle of promissory step. Once you make a promise to do something, and you can back, Miller, after discharging of part. And the third, Miller, I advising the legitimate expectation. Once there is, you gave a calculation, and you paid. I discharge my obligation. No have that I have allegation that I have not, Miller, completed the work or violated any terms. You say this work is satisfactorily completed, approved the EOT and paid, partly paid, but the remaining amount you are taking. That is my humble suggestion.
And in this case, we filed a preliminary counter affidavit to the market. And we need to file another affidavit because there is some development in the meantime. Let's see, kind have a glance to page 4 of our affidavit. Actually, it was framed before the comment, and then somebody
he has gone and have taken a very basic point. He says that you have withheld the money on the ground that there will be a discussion, there will be modalities that will be decided also far as the price escalation and the future modalities have to be decided. He says that even if you decide a future modality, that will not invalidate or affect the existing contract or the contract which was entered. Because he says that those would operate prospectively and therefore will not affect his right. In that, even what more affidavit? Even if you have taken a decision,
Actually,
can you make it from a retrospective operation?
one thing is to be brought to the record, Miller, factually, Miller. He is relying upon page 43, that is the office memorandum dated 2020, 2012, under which he is claiming that, Miller. My humble submission is that, Miller, this office memorandum is already passed by this honorable court in execution, Miller. I will file that judgment.
What?
Yes, sir. Which one? Page 43, Miller. Page 43, 43, Miller.
Oh.
Okay, yes, Miller. Office, as per office memorandum number 12606 dated 24/12/2020.
He is relying on that.
Yes, Miller. That is already.
He is not relying on that.
I'm the condition modalities, Miller. I am on the contractual liability of the state, Miller.
Correct.
I'm saying as per the formula.
He has not relied on anything. He simply says 21 or 24, 12, 2020, 2000 that you have relied.
Yes.
Has it been quashed?
So that was quashed, Miller. The circular was quashed.
That is also quashed.
Which one?
The 24/12/2012 circular was quashed.
Then if it is quashed,
then Miller, the modalities which has been fixed in the contract quantification, that was
the contract shows. You have the clause of the contract.
Your Lordship.
Because the clause of the contract.
Your Lordship. Your Lordship, page 43, Your Lordship.
Yes.
Page 43.
Page?
Page 43, Your Lordship, annexure. Annexure 4. Your Lordship, annexure 4 is the date of contract, Your Lordship. Page 24 starts.
Page 44, 43, what?
Miller, annexure 4, page 43, Your Lordship.
Yes.
Your Lordship, top. This is the office memorandum dated, Your Lordship. Page 43, Your Lordship.
This has been quashed.
This circular has been quashed on the contractor association case. But the clause, Miller.
That is not submitted by Miller from the beginning.
I have already said.
Submitted regarding BKD judgment that is related
No.
to 2020.
The BKD has referred.
Please show me from the terms of the contract that it constitute an integral part thereof.
Yes, Your Lordship. Paragraph 31A, Your Lordship. Your Lordship, paragraph 31 starts.
Clause of the agreement.
Yes, Your Lordship.
These where? Which page?
Miller, same page, Your Lordship. This is the Miller, Your Lordship, just before that clause 30, page 42, Your Lordship, is the page clause 30, page 30, clause 31, the next clause, Your Lordship.
That was a clause of a memorandum.
No, Miller, this is a clause, contract clause. Your Lordship, kindly, I requesting Your Lordship.
Oh, there is a separate exhibit. Oh. Yes, I got it.
Your Lordship, the clause is.
Yes, that it's the separately when it is incorporated that you can't do pass.
This is as per that circular.
No, whatever. But you have incorporated in the agreement.
Yes.
You have incorporated in the agreement.
As per that circular.
Right.
And
now that circular goes below. That is the predicament. I need to file an affidavit to write.
Paid part of amount paid, and you approved the escalation amount in
And also
2022.
That 46 million, but you can see towards the bottom. Application of
Where is
escalation.
the circular of 24?
Yes, not filed.
So, we resign the clause, Your Lordship. No, it's not going correct.
Just we wanted to look at it.
The circular is not, it's not, we are not, Pitson is not valid. We relying the clause as well. We are not.
No, I understand. Let us see, sir, when he is raising a issue that the circular has already been passed.
Yes.
Then in that event, let us see the circular, what it says. Because this
paragraph 31 AI is an integral part of the agreement. So that is why we wanted to just understand from that circular to make a distinction. Do you have the copy?
No. I present.
Give us.
Inside.
When?
Also next week. Or day after tomorrow.
Yeah. Day after tomorrow.
Yes, officer.
Give it. Just give that circular.
Yes,
Day after tomorrow.
yes.
Number 34.
So in this matter, Lordship, the petitioner challenge, the competence of the sub-collector, by the change of law, now it has come to the deal in Minds Lordship. Still in Minds Lordship, now the sub-collector, that was the appellate authority Lordship, didn't rule Lordship. Still, Lordship is about the matter, and he was decided the matter, and Lordship last acted as Lordship prevented him not to interfere with Lordship. And Lordship can they filed a counter. And Lordship can see that
What is the stand taken in the council?
counter that justifying their stand, and they have come up with a heavy courage, Lordship. Still they're coming, they have cancelled the Lordship the weight. They're saying no, you are disqualified because we have capacity, because by of representation, and we have been authorized because the file has moved to me, to the sub-collector. Yes, by way of a meeting Lordship, by a proceeding, he has cancelled my bid Lordship. They have come up with this affidavit. So that was not within my knowledge, but they have given the statement in that.
The Tehsildar has affirmed.
Yes. This is the counter of this Tehsildar Lordship.
Yes.
Page 60 Lordship, page 60. Page 60 of the Lordship, the counter filed by Tehsildar, so that is 25, 2025 Lordship. Is 1.60. I don't know.
Yes.
Yes, Lordship, can you come to page 65? The signatories, Lordship, kindly see. The page 65. Lordship, they have given the signature below the proceeding Lordship. Sub-collector there, Lordship. Revenue inspector there. Tehsildar Gopal Nagar there. Revenue supervisor there. And mining officer alone is there, Lordship, kindly see. And that is on 19/11/125. When already, Lordship, they don't have the power, they have taken this decision.
24.
24 Lordship, 19/11 and 24.
Yes.
And in all Lordship pages, all the paragraphs of the counter that justify their stand, Lordship, we have the power. Because by way of representation, because the representation has come to us, we have this decision, Lordship, they justify their stand, Lordship.
Yes. Where is the law?
Lordship, can you see, Lordship, this amendment? This amendment came, Lordship, on 25/4/123. Orissa, Lordship. New law, Lordship, that is.
2016 rules.
2016 amendment 2023, Lordship.
Which one?
Lordship, Rule 27, Lordship, kindly see.
Rule
27, it was the earlier Lordship, the competent authority. In old rules, Lordship,
Yes.
the Tahsildar was the competent authority. And the sub-collector was the Lordship, the appellate authority, and the collector was the Lordship controlling authority.
Yes.
That's why as per Schedule 4, Lordship, and it is amended for 23. Now it's the mining officer is the competent authority, and it the entire authority transferred to the Steel and Mines Department. It was earlier under the Revenue Department, Lordship. Schedule 4 is the Lordship,
Yes.
authority. In old rules, Lordship, there is the Tahsildar was the competent authority.
Yes,
Lordship, Lordship, but the sub-collector has passed the SHADA, Lordship, despite the Lordship SHADA.
Tell me.
Yes, Manoj. There are few important facts to be mentioned in this matter, Manoj, which have been mentioned in the counter affidavit, Manoj. Manoj, first, initially, when the notification had come into the picture, at that point of time, it was transferred from the Tehsildar to the mining officer. Thereafter, there was a meeting on 13/6/2024, which is annexed as annexure F/5, number 43 of the counter, Manoj. Of the counter filed by opening number 1, 3, 4, and 5, Manoj. If I may refer to that document.
Is the minutes of the meeting?
Yes, Manoj. If I may refer, it starts on page 41. Third paragraph, Manoj, last line. Similarly, the sources in respect of which there are litigations pending in different.
Page 43.
Yes, Manoj.
Last paragraph.
Yeah, third paragraph, third last line. Similarly, Manoj. The paragraph starts from the advisor,
Yes.
third last line. Similarly, the sources in respect of which there are litigation pending in different fora are to be taken over only after settlement of said litigations, Manoj. Manoj, in the counter.
The only thing is.
Yes, Manoj.
Can an authority who is a creature of a statute, who feels his birth from the statute, take a decision contrary to the statute?
My lords, in that notification itself, there was a transitory provision also, Rule 66(3), my lords.
Transitory provisions was not incorporated here.
Yes, my lords, it has come through the amendment.
Was that transitory that those powers are still retained?
Yes, my lords,
Because once it is brought in section 27, then what remains?
my lords, 66, sub-rule 3, my lords, if I may read.
Rule 66.
Of Odisha minor minerals rules, my lords.
Yes.
66(3).
Yes.
This was inserted in the said amendment 27/12.
Correct.
Notwithstanding anything to the contrary contained in the amended provision, till the new system is put in place, the existing arrangement would continue. The state government may take necessary steps for effective transition of minor minerals from revenue and DM department to steel and mines departments. So immediately it was not, all the sources were not immediately transferred. because it was a slow process in which everything was slowly transferred. And in between that, this minutes of the meeting came into the picture where the litigations were pending or in those cases, the initial, whoever, the authority who were concerned, authority, revenue department, continues to manage those sources till the property or the sources are litigation free, my lords.
Yes.
Yes, my lord. And subsequent to that order, my lord, the Tehsildar by his letter dated 30/8/2024 transferred the sources back. And accordingly, my lords, if I may refer to page number 6 of my counter, 6 and 7, my lords, where the entire process, how it has been done, is explained, my lords.
67.
Page 6 of counter affidavit of OP 1, 3, 4, and 5.
Yes.
Para 12. Para 13.
The date of the order of cancellation.
That is small chapter, Lordship. That is 1911, 2024.
24, 1911.
Lordship. It's 38 and trust.
And it's in then para 13 also.
And this is in relation to this Gopa for
Lordship. Gopa Bandhanagar, Lordship.
This is what I have. What you have said in paragraph. Keep in mind, you have invited our attention to rule 66(3).
Yes, my lord.
Keep in mind, now read paragraph.
It's 13 minutes.
12.
12 minutes. That is humbly submitted that after completing the tender process wide annexion round, opposite party number 5, Tehsildar Gopabandhu Nagar, transfer the minor mineral sources under Gopabandhu Nagar wide letter dated 30/8/2024. Yes, my lord.
This.
So, my lord.
Cooperate for August 2024.
And it's
What is saying?
till the new system is put in place, my lord.
What does it mean?
till it is transferred.
It is transferred on 30th of August.
Then
once and also in the month of November 21.
Well, it's para 13 if I.
Once he transferred on 30th of August, then he ceases at least from that day.
Well, it's para 13 miles if I may read.
That is what I read.
The view of the letter by annexure F by 5, while his letter dated 30/8/2024 had transferred the records concerning the source in question to the mining officer Mayurganj, but opposite party number 6, mining officer Mayurganj, upon receipt of the complaint dated 3/9/2024 by annexure T by 5 series returned. Because it was during the process of the tender, it was with respect to the issue was
Talks about when the parties have closed the court. If we have to interpret the word litigation in the perspective of your authorities, I think it would be. What should I use the word? I have a very bad word in my mind. I do not want to. Can't be done. There was no pending litigation. The process, the tender was floated, tender process was done, and then because of the change of law, he transferred everything to on 30th August. Then he ceases to have any powers under this act from 30th of August.
once it was transferred from mining officer, thereafter only Tehsildar resumed and
how can he?
In light of this minutes dated 30.
This minute says litigation, but there was no pending litigation. Was there any court proceeding?
Yes.
Pending?
Two petitions.
Was there any court proceeding pending? Yes.
Well, it's 2 writ petitions were pending, my lords.
Relating to this?
Yes, my lords.
Yes.
Very much prior lordship and pursuant that direction, they completed the production process. It is much prior to the lordship.
That was in relation to auction.
Auction lordship.
What do you mean, auction? How it has got any nexus to this? Cancellation? The auction process is something different. That's a separate cause of action. And after you completed, the paragraph here says that I have completed the auction and then handed over. Now, you say that completing the tender process. Now I'm handing over to you. Now you take care of the same.
May I assist, my lord? I am for the opposite part number 7, my lord.
What is this? Who are you? Tehsildar?
No. I am the independent, I am the second highest bidder, my lord. He has made me a party.
Let the government justify.
My lords, if I may refer to page 70.
What?
Page 70, annexure Q by 5, my lords, which gives the brief history of the case.
What?
In that, say, if I may read that portion, my lords, regarding the pending litigation aspect, my lord.
Pending litigation relating what?
In the same matter, my lords, same tender process where
So what is there between the same parties?
Yes, my lords, page 70, my lords.
Page 70.
70 of the said affidavit. Second paragraph. The brief history of the case is that the auction notification for such and such was published on 23/9/2000. In the meantime, writ petition number so and so 2023 by filed and disposed of on 21/6/2024 by Honorable High Court, which with the tender in accordance with law after receipt of clarification from the district office dated 5/8/2024. The tender was open and finalized in favor of the highest bidder, Dilip Kumar Sahu, the petitioner hearing, my lords, who had offered additional so and so, sir. Accordingly, TMC record was sent to the mining officer, M.R.PATHAK being the competent authority, date on 30th August 2000 for necessary issue of Form L. After receipt, my lords, thereafter, my lords, after receipt of the complaint petition by the second highest bidder, on 39, alleged that the Dilip Kumar Sahu had submitted single solvency certificate for so and so and solvency is inadequate for both the sand bed. Hence, he requested to declare him as instead of Dilip Kumar Saumana. This is a continuous process whereby there is still a pending.
Had a lot of some aspirations. Apply your judicial mind. Don't say anything which you know is, when you talk about the pending litigation, then you should know that what is the dealing of the pending litigation. At least on 30th of August 2020, no pending litigation. You yourself have like it. It ended in the month of June.
Only on 3rd September.
Can you say, I'm asking you,
This is the stand taken by the state, it's only after 4 days.
will you not apply your independent mind as a legal officer?
Yes, it's the only
Will
point.
you not? When the court, the bench is asking you a specific question.
Yes,
Was there any pending litigation as on 30th of August 2024? Your answer should be yes or no. You cannot take us to a situation where the pending litigation relating to a tender process disposed of directing the authorities to proceed with the tender. He is challenging an action of cancellation of the tender or his candidature or his bid is cancelled after being adjudged as the highest. And that came in the month of November 2021. When on 30th of August, yes, this SLR is transferred to the money. Can he still resume and say, I will cancel? And he says after completion of the tender process, I am forwarding. What is the meaning of that word, completion of the tender process?
Yes, please.
No. Now, lease deed has to be executed by a competent authority. And you are taking me to a particular place where the litigation has already ended. This is not expected. At least from you, I never expect. That's a very important provision section by Rule 66(3). I understand that so long as new system is put in the but once the government is transferred, how can a old officer who is not a competent authority now assume to do the question lies here.
Yes, my lord. Yes, please. Yes, my lords. My lords, that portion I understood, my lords. Only after 30th August he had transferred. My lords, the 4/9, the complaint was received. My lords, if I may refer to the prayer in the reputation, my lords, what is sought to be quashed in this matter, my lords? That's the only order which is sought. What is?
Let's say, I need to find nothing to say on merit. It's a technical. Do not allow the court to enter into the merit. When both the parties have exchanged. The issues having a dignity. I think the people for such other or further order the choice you got. Testify yes. Now, it was the same. Let us hear the case law. As well, you want to get it like the
As far as enlightened what is concerned, well, I think.
Sir, the law is very well settled.
Well, I have understood it.
Law is well settled.
Well, I have understood the entire thing.
Law is the creature of a statute. So here the statute confers power on. It is not to the act. That's the only principle, the oldest principles I know.
Well, I have understood that part, and also I have seen, well, what my learned friend argued, well, and I have been also observing my lord's observation with regard to the entire aspect, well, just to assist my lord's, well,
Yes, yes.
that will be, well, how, when the facts have become.
Mind is open, sir.
Yeah, well,
Don't say that it is closed. This is what we wanted to understand. Yes.
well, I still will go by what my learned friend was showing, the prayer portion, Lordship may kindly see, well, or I'll have to just assist to that, leave it to your Lordship.
Don't worry.
I don't stand in the way, and also you have. Well, exactly what I'm saying, Bala, the prayer, what has been made here, and what has been done by the authorities in tandem with the prayer. Well, that is what exactly will Lordship, just give me 2-3 minutes time, Bala. Yes. Well, I don't use it. But even AIA 1954 Supreme Court page 340, it says if a court doesn't have a jurisdiction, passes an order is a nullity. Yes, yes. Exactly, man. But I cannot run away or from that particular principle to satisfy. Well, that is the principle. So that principle is always alarming in my mind. So I can't argue anything which will be offensive to that principle. For my own satisfaction, she just sees page 10 and 11 of the writ petition. Well, what has been sought for here?
I'm reminding you of a Nazir Ahmed's judgment. Yeah, 1956 UV conference. Same principle.
Well, in fact, Privy Council are the golden principle. Anytime, Malad. And after Privy Council till 1970, Malad, all the judgments are golden principles. I would not say that after that. Yes. Malad, why I'm saying that the purpose of showing, Malad? Malad, that has been.
As the jurisdiction and competence.
Now, Lordship just sees that page 207. Thank you so much. This is the page.
What's the prayer you
Prayer is to issue a writ of mandamus to quash the orders of the sub-collector Kaptipata.
Lordship. He is seeking for caution of that order.
Yes, but no.
November 2024.
No.
Lordship, for a moment, let's kindly see.
No.
Lordship. Yes, Lordship. The action of the
November 2024.
no, Lordship. The collect
That's all we wanted that.
Lordship. It must be
Pause there. That's the only thing.
Well, the prayers, well, the documents which I mean, letters which are sought to be quashed, Millard. These are all letters, Millard, rescheduling the auction. Lordship means that is what I'm showing to your Lordship. The competence of the person. One second. Sorry, Lordship. Lordship, that is what I'm showing to your Lordship, Millard, and next at 10 series at page 67 and 269.
When how he has been adjusted as the L1 and UR and when
27/8/2024.
Already done.
Already done.
Then what he does not challenge because he's
L1. So
but you made a complaint thereafter.
A complaint thereafter,
And on the basis of your complaint, he passed an order in November disqualifying him.
Lordship, that is not challenged. What is being
Order is not challenged. This
I'm not being Lordship. Kindly for a moment, Lordship. The beginning, I'm saying we should appreciate their courage, Lordship. Lordship, kindly see. This document given RTI, Lordship, not my friend, Lordship, officers, Lordship. 24/6/25, they're giving a certain Lordship, kindly see the proceeding, Lordship. On Lordship, on June 25, they're saying I am the highest bidder, and they're not disclosing this development, Lordship. For the first time in counter, Lordship, we came to know that they have taken this decision. And behind our back, Lordship, and behind the Lordship, they're not bringing knowledge of this court also, Lordship. This matter is subjudice. I'm claiming here for, please issue me H1 certificate for the highest bidder. Please execute agreement with me because I am the highest bidder. Lordship, kindly see this document. This document is given on 24/6/2025 under that you are the highest bidder. Lordship, kindly see the document, Lordship. And Lordship, in the meantime, Lordship,
may I just conclude?
They have brought my learned friend stand.
I'll not take much time. I have also appreciated Mallard's in fact opened the mind. Absolutely, Mallard. So, but just to bring it to Mallard's notice, Mallard, Annex 10 at page 68. Mallard, here, with reference to the subject cited above, Mallard, here to Mr. Dilip Kumar Sahu by the sub-collector. That the hearing on the complaint petition filed on second highest bidder, so and so, on 3rd of September 2024, relating to the auction notification so and so, and it has been rescheduled to 21st of October 2024 by the sub-collector. Yes. So this is letter definitely without jurisdiction.
So definitely the chain of the actions which he assumed jurisdiction.
Yes.
After that has to go.
That means, Mallard, the rescheduling, Mallard, he has participated.
There are three kind of a jurisdiction so far as the courts enjoy.
Yes.
One is in relation to territorial, one in relation to pecuniary, and third, so far as the planetary or inherent jurisdiction is concerned. When the authority also exercises, then he has to exercise the jurisdiction conferred by law.
Correct.
The inherent lack of jurisdiction, you have referred AI 1954.
Yes.
If it is inherent lack of jurisdiction, then
it cannot be cured.
The order is nullity.
It cannot, even the parties agree, Mallard, to confer it cannot be done. Section 28 of the Contract Act bars that plan.
Even the jurisdiction cannot be created into an authority.
Exactly, Mallard. Exactly, Mallard. No, why I am saying, Mallard?
So what remains, then all these actions after 38 that is what is the challenge.
But here at Lordship C at page 270, Annexer C by 6 filed by the Mallard Mines Officer. The Mines Officer says, Mallard, that after he was given, Lordship, kindly see page 280.
A continuous page.
I'm sorry, but there's no Lordship, the internal page 19.
Yes.
Counter affidavit filed by the Mines Officer and the Steel and Mines Department, 2 and 6. Mallard, Annexer C by 6, Mallard. Mallard, Lordship will see it. I'm reading the para, Mallard. In the meanwhile, after receipt of the letter from your high office, filed so and so, the tender opening committee felt necessary to issue a fresh notice to Sahu
the first highest bidder to provide him ample opportunity of being heard by sending him with a copy of the allegation petition along with its annexure submitted before me, that is the mining officer Baripada, on 3rd September 2024. This is the mines officer rights for that. And written submission filed by the Simmons on the date of the hearing on 21st of October 2024 by the officer order number so and so. Then, my lord, the committee, this is the committee, mines officer, sub-collector.
There be a committee for that.
But this was the
competent authority who has to take a decision. Authority after this amendment is the
mining officer.
If he alone is a competent authority, then the committee will say.
Wait. I just showed your lordship what is on record. And
assuming the power is the very difficult.
People are rightly said, an authority who derives a power under a statute has to work, and the entire thing has to be circumscribed within the statute itself. Right, Parag. So let it go back to the mines officer for decision.
Whatever.
Yes.
You want to take, let it take, but this order cannot sustain.
So let the competent authority will decide by that. Now, since the competent authority is there, and let him decide with regard to
there is a fundamental, there's the first line of principles. First principles, we always say the person must know the first principles. That a person can do anything individual unless forbidden by law. Yes. A statutory authority cannot do anything unless provided by law.
Yes.
That's the first principle. You have to travel within the circle.
Go back to the competent authority for decision. Go back to the competent authority for decision.
It is up to them, Lordship. Open to them, Lordship, to take a decision.
If they do not want to pursue, they will not.
Lordship, two resolutions, that is, Lordship, that only by of counter they have brought, Lordship, two documents. That is enough because
have you not felt the pulse of the thing?
Lordship, no, Lordship, because the confirmed Lordship, only two documents I am showing, Lordship, that has to be passed. Lordship, only. Grateful, Lordship. Grateful, Lordship.
35.
May I give the lordship on behalf of Mr. Pathak, senior advocate, that present date petition and written become instructions.
So you want to dismiss for not prosecution or dismiss as an infractions? Submitted by the council. You are the advocate in the court.
No,
What you're good.
Six, I am appearing for the petitioner. But just now I received a copy from the opposite party number 4. State has not filed the counter affidavit.
That's too big claim. Inviting you to file counter.
Already there is a direction to file the counter affidavit.
I filed it within 2 weeks, so not 2 weeks time.
That's too weak.
There is a-
I have already out of the state police.
You can file within that.
Yes. There is an interim order that may be extended.
Next thing.
Item 37.
Yes.
Opposite number 2 has filed counter affidavit. And the copy has not been given to you. No.
Like tomorrow, I've served only tomorrow, let's see.
You have to take instructions, man. At least 1 week time. 1 week time. The copy of the counter affidavit is served. It has been served to you now.
Yes.
Now. This is the interim article.
Next item.
What was meeting with this?
The very next item, item number 38 minutes. I have filed IA number 12099. That is IA for amendment. I am not pressing that, Millet. Only I am saying that I'll file another IA for amendment. That is.
Leftover matters may be taken up tomorrow. 47.
Too much.